That was pretty quiet. Is that just on your computer?
Yes, I was starting it up, and then I have to do the share screen real quick.
Remember when you share screen, there's little boxes in the corner about sharing audio if you want to do that to maximize the fidelity. It's not working.
Hold on, I think it's, when I go to screen share, it's not showing up as an available window.
Well, I'll tell you what, that's something you can mess with from your desk
Sure.
while we press on with Mr. Morris. And hopefully you're able to sort that out.
Yes, sir. Thank you.
All right, let's get on the record. Good afternoon, Ms. Fuse. How are you doing?
Good, how are you?
I'm well. I appreciate you deciding to come back. We are back on the record in Shackleford versus Georgia Power. It is a little after 1 o'clock on the 14th of December. We are hoping to run our session from about 1 to about 6 today because of the conflict I had this morning. We have Mr. Shackleford and his lawyer here. I don't know where the corporate representative went.
Because we need to take up the note, which I found, I think it would be appropriate for Mr. Morris to stay out there, given that he's on the stand. So he doesn't hear us talking about it. So he is here, but outside, so that we can discuss that note.
Okay, I saw him when I walked in, so I was surprised he wasn't in court, but he's available when needed. We do have Mr. Archer and Ms. Peeler here, so I think we're able to get started. When we broke last night, Mr. Ramsey had expressed some concern, even frustration, that Mr. Morris had testified repeatedly and extensively about a long report that he prepared for Georgia Power in connection with the accident in August of 2019. And his lawyers seem to be caught unawares of the existence of this. Mr. Archer said he just found it. I look forward to hearing what find means, and let's talk about how we're going to navigate whatever it is you found.
It was in my file. It should have been produced. It was, there are 3 pages there. After last night, we contacted the client and obviously looked at our file. The way this occurred when we got sued, Georgia Power produced to us everything they've done. This was in there. The second page is the note. The only thing I have said to Mr. Morris is as soon as we found it, I took it to him and showed it, and I said, "Is this the note?" And he said it was. It is physically longer. It is the same thing. I believe there is a word difference. As I said, this is not Georgia Power's fault. This is my fault. I have talked with Mr. Ramsey, and what I proposed to him, and I'm not suggesting we have an agreement. I just want to announce to the court what I proposed to him is that I will not address this with Mr. Morris as I continue my direct, and that when I finish my direct, he can call him for recross, which I assume he would anyway, but he would have the first shot at him and say, "We talked about this, and I just got this from your lawyers." I'm not suggesting what questions you would have, but bottom line is I don't get the advantage of trying to dilute whatever impact there is from this note that I should have produced.
Okay, a couple questions. One, when you say it is almost verbatim what was in the report that Mr. Ramsey was talking about, there was a one-pager that had, Mr. Ramsey kept referring to paragraphs, that may have been the structure, it really was sentences. And what you're saying, Mr. Archer, is that typewritten document is effectively not the distillation, it was meant to be maybe verbatim what Mr. Morris wrote on this kind of small binder paper that I had.
Yeah, I think there is a word, and I don't, do you have the, identified the word, and I forget, I don't think it's meaningful. I literally think it appears that the typewritten is verbatim with the exception of perhaps a single word, like it says 605 on the left. I'm not sure that says it, but it appears to me that someone tried to type it verbatim and they just missed the word.
Okay, and did Mr. Morris confirm to you, and he can do this on the stand during recross, that this is what he had in mind when he was testifying about writing out something?
Yes, so I felt like because of the issue, because he's on the stand, that I needed to limit my questions to this. Mr. Morris, we just found this. Is this your handwriting? Yes. Is this the handwritten statement that you were describing that you have not seen since you did it? Yes, sir. I ended it there and walked back to a different room. But he confirmed that this is what he was thinking of. He absolutely described it as longer. It is physically longer. It is word count not.
Okay, got it. Yeah, it is underwhelming in its length, but it also makes more sense as to where the typewritten document came from. It wasn't someone who overheard Mr. Morris and said, I'm going to summarize it in this way.
That's right.
Last question I've got for you. Is there reason to be concerned that there are other things lurking in your files that Mr. Ramsey didn't get?
So when we found that, I said the obvious follow-up question is there anything else? We have scoured. So as we left last night, the first thing we did is call the people at Georgia Power who are responsible for collecting the investigatory file to talk to everybody involved in it, and they confirmed that they turned over to Balch everything they had. When we found this, we reviewed again our file to make sure we produced everything. We did not produce a privilege log. There are no privileged documents. So there are two other pages that I think that have some notes that are not from Mr. Morris. They are from a fella named Moorhead, who was the safety supervisor. And there are some handwritten notes there. Most of it is names. And those two pages are the only two pages. They were also not produced. They are not statements, but still probably should have been produced. And so based on our review of our file, which I believe was everything from Georgia Power, it's just these 3 pages.
Okay. Got it. Mr. Ramsey, your thoughts about how best to proceed with this late disclosure?
Your Honor, I was kind of with Mr. Archer till the very end there. He said that there was a portion of it that was by Mr. Moorhead.
The note, I gave you so that cover sheet.
Okay, that's something that we're saying Mr. Moorhead wrote?
Yes.
Okay. The very first where it talks about the case number and all that stuff is, okay, that's Mr. Moorhead.
Yes.
Okay.
And this is how it was organized. Those notes, name of your client, the responding officer, then Morris's notes, and then this Highway 106 in New Point, mile marker 1. And that faded is
the back of the other page,
yes.
right? So the first page what you're showing me was Mr. Moorhead.
Yes.
And second and third were written by,
No.
or I'm sorry.
Second page, Morris. That's the statement that he was referring to.
Okay.
And then the third page with the notation, that's Moorhead.
Okay, so first and third are Moorhead.
Yes.
Second is
It's Morris.
Mr. Morris.
Yes.
Okay. And Your Honor, obviously I'm sorry to hear it was Mr. Archer's mistake. I would much rather have been his client's mistake, but so I'm not trying to not show some grace toward him, but But again, the timing of this is difficult because, and I would just ask if Your Honor, I don't know what the right remedy is, that I'd be allowed some latitude to kind of explore with Mr. Morris, again, I didn't even know that they sent me this last night and I was under the impression, okay, Morris wrote all of this then, I guess. Now I'm hearing, okay, it was Mr. Moorhead that wrote pages 1 and 3. So I guess I'll just need to explore that with Mr. Morris on the stand and understand what portion of it he wrote and, explore what the differences are between those two documents.
Sure.
And Your Honor, I would also ask, I understand Your Honor probably wants to craft the most conservative remedy possible, but I think we ought to be able to, without saying, hey, they committed a discovery violation, we ought to be able to say, Mr. Morris, we just received this last night, didn't we? And I think that's fair to present to him that that's when we received it and make sure the jury understands that's when we got his handwritten statement.
Okay, I agree. And I think all of that was contained within Mr. Archer's recommended approach.
Yes.
That he, Mr. Archer, will not touch this document during the remainder of his direct examination. You'll get up on recross and have at it. You can get Mr. Morris to confirm, if he does, Moorhead is page 1 and 3, as opposed to, no, that's just, that's when I write with my left hand. It's like this. He's gonna tell you whatever he does.
Right.
You're also free to say, gosh, when did you first get confronted with this? By my lawyer last night. So I didn't get it till last night, along with the jury if you want.
Right.
All okay.
Okay.
I think we don't need to focus on, was it Archer or Balch or
Right,
George
right.
Power? It was late disclosed, and you're free to get that out of Mr. Morris and do with it as you see fit in closing. I don't know how much traction it gets you if in fact it's the same.
Right.
And that's the reason why I'm less concerned about prejudice for Mr. Shackleford here, because if this document had something radically different, then that could affect Mr. Kidd's work, it could affect the way you presented things.
Right.
But it sounds like, and you'll be the ultimate arbiter of it, the jury will, but you will with your examination of Mr. Morris, that the handwritten page 2 of this item tracks almost verbatim the document you've had all along and that you spent a fair amount of time with Mr. Morris on. So I don't feel like you're getting cut off at the knees with this surprise disclosure in the middle of trial. And so that's why I think the remedy that Mr. Archer described fits the nature of the situation in which we find ourselves, because you've basically been given the original of the document that you've had all along. It's the handwritten original, the source material for the typed report that you worked with Mr. Morris on.
Right, and we will certainly agree that it's similar, that there are some differences, and I'll explore those with Mr. Morris. Yeah.
And you should feel free to do that, and that your lawyers didn't show you until last night. And again, I don't know that Mr. Morris is gonna be able to say, of course, you didn't get it, but I will overrule an objection should you say, let me represent to you, Mr. Morris, that I only received this last night.
Right.
As you kind of quasi testifying, but I'm authorizing that.
Okay, thank you, Your Honor.
All right. So then, is there anything else logistically or legally we need to cover from plaintiff's side?
And I'm not sure when you want to take some of these things up, Your Honor. You had asked me to prepare the judicial notice for Phase of the Moon. I did that and sent it in last night, so I don't know if you wanted to take a look at that now or do it later.
I don't want to right now. You sent it to Ms. Niles. I don't think I've seen it, but Ms. Niles may have sent it to me. I've been working on, I was doing other stuff this morning. Who did you send it to? Or did you file?
I think I e-filed it, Your Honor. I don't think I sent an email.
Okay.
I do have physical copies of it here as well.
I love a physical copy,
Okay.
but before you bring anything else, you said there were several things you wanted to talk about.
The other thing, I did amend our summary of medical expenses, and with counsel's permission, I will just substitute that front page for the front page we did have. And of course, I think we already took out the future medical bill. And we're going to plan to recall Mr. Shackleford just very briefly for that and a couple other short things, but just so he can confirm, yeah, this is because he didn't do that and because of that other issue before.
Okay.
So there's that. There was another, when we plan to recall Mr. Shackleford, again, just in kind of full disclosure, and I already handed a copy to counsel. I don't think he had a chance to kind of weigh in on it. There is one Your Honor, in our pretrial order, we did say, hey, we're going to, our potential exhibits are going to be medical bills and medical records. And in all candor, I did not plan on putting in chunks of medical records in any respect, because I think if there's opinions expressed and things like that, we would have to have that person here. Now, Your Honor, especially in light of the jury's concern about, well, was he ever drinking alcohol? We were able to get, and we do have a record certification for the Stevens County medical record. And what my proffered exhibit is that I shared with counsel a short while ago was they did a CBC, they did a blood test on him when he went to the hospital. My proposal is to have that 2-page test result. There now, the second page has some writing below the test result, and we would redact all of that. But just to introduce that through Mr. Shackleford, that while you were at the hospital, this is what tests you understand you took, and here's what the result was. Your Honor, I think it's not as prejudiced. I would understand if there was some medical opinion, some doctor saying, I find that he was not drinking that night. I'm not trying to do that. I'm just saying you've got a CBC medical test result. It said you didn't have alcohol in your system. Just want that, to introduce that through him. And what's good for the goose is good for the gander. I believe they have a test result for Mr. Morris, and I wouldn't object if they want to put that in and say, hey, he wasn't drinking, or he didn't have alcohol in his system either. But that's what we would proffer as an exhibit. And obviously, I wanted to make sure I brought it to opposing counsel's attention and to your attention before we just get up there and try to do that. So
Okay, so judicial notice, you've modified the summary and the medical records request. Anything else?
I believe that's it at this time.
Okay, if I could have a copy of the judicial notice, and as long as you get one to the defense as well.
Yes. Okay, give this to you.
Yeah.
Thank you. All right, Mr. Archer, first I'm going to table the judicial notice. I want to read it, and then we'll talk about it before, outside the presence of the jury, before I do anything with the judicial notice. The summary, the amended summary, have you had a chance to look at that? Any objections to that?
I think the math is wrong. No objection. He's pulled out but and it's not radically wrong, but I get 25,264.07.
Okay.
And so it's within a few $100, but
Okay.
but
Well,
let's
I
clean up the
assume
math.
he wants good math.
Yeah. Well, maybe he does. The bad math gets him another $500. So.
We'll be giving the jury a calculator, so he may not want that math caught.
Yeah.
But assuming the math is corrected, the format and the contents, no objection.
No objection. No objection.
Okay. And what about the medical records concerning the blood work, about which we've already received some testimony?
Yeah. So we've got a records certification. The one issue I have is I'm not sure Mr. Shackleford is. I don't think he is capable of interpreting the test. So this may not be hearsay under the business record exception, although we don't have someone. We've got the certification, but I don't think Mr. Shackleford can explain the meaning of it says alcohol less than 10. And so
So you don't necessarily object to the admission of these records because there's basically foundation and authentication provided by the certification, but we wouldn't have the right witness on the stand. I don't think there is a witness, a callable witness on Mr. Ramsey's list to say this is what that means. The jury can do what it will with it, but it won't be Mr. Shackleford who would be saying, let me tell you what alcohol less than 10 means. I agree with that. And so I want to make sure, other than Mr. Shackleford saying I submitted to blood work when I was there, I don't know that he ought to say, let me explain to you these complicated medical forms.
Right. And just to kind of, for the limitation, just kind of explain what we would say. We would ask him if he did go, when he did go to the hospital, if it's his understanding that he did get a blood work test done, as say is, and hand of this, is this your understanding that this is the blood work test you received? Yes, it is.
Yeah.
And then I may just direct him to the results and just have him confirm what the result was without asking any explanation of what that means. Just that, oh, hey, it says here it was less than 10.
I think you can publish it. I guess you can have him read it as long as
no further comment needed on.
I don't see an issue with that, other than one could object, the document says what it says. It doesn't, I don't think that precludes a witness from reading something aloud so the jurors can hear what it says if it's kind of blurry, but it sounds like you do not intend to have Mr. Shackleford saying, oh, by the way, that was good news for me.
No, yeah. I think the only other question I would perhaps proffer to him is, did you have any understanding based on your visit to the hospital that day of whether you had alcohol in your system or not?
Well, then you get into hearsay, because it would be a doctor saying,
That'd be,
you know what, this is what it
communication.
means.
Okay.
So he's already testified, Mr. Shackleford, I didn't have any alcohol in my system.
Right.
And you're going to contend that these results support that.
Okay.
And you can argue what you want to argue during closing, as long as you aren't testifying while you're giving your closing as to how to interpret something like that.
Right. Okay. That's fair. Thank you.
Given those directions, any objection, Mr. Archer?
What he, as I understand it, he also intends to redact the nurse's notes, and I object to that. I think we should have the whole thing in, because it tells the whole story of his presentation to the hospital, and I think the entire medical record should go in. The redactions are not. The language on the rest of it is all related to his presentation at the emergency room, and it's all relevant.
Okay, well, it may have been that Mr. Ramsey was redacting because he thought you'd object to it. You're not objecting. Do you have any issue, Mr. Ramsey, with, how about this? I want to get the jury in here. You guys work through that part.
Absolutely.
It's coming in. The question is redacted or not. And we'll table that.
All right.
Mr. Archer, did you have any legal or logistical issues before we bring the jury?
No, Your Honor.
All right, let's make sure the jurors are ready, and if someone can get Mr. Morris back in.
Yeah. Both things. Basically, the alcohol's the issue here. You know.
All right, jurors. We're the bridge.
Welcome to be seated. Welcome back, ladies and gentlemen. Happy Wednesday. It's hump day. So that means we're halfway or so done with this trial. It's gloomy, gray, and wet outside. It's a perfect day being 9J for a trial. We had on the screen that little holiday Yule log burning. This would be very fast, but that's not what we're going to have up on the screen. I appreciate everyone being on time. We had to work through a few more legal matters so that things can flow smoothly today and early tomorrow. When we left off yesterday, Mr. Morris was in the midst of his direct exam. And for you legal eagles, that's a little backwards because the plaintiff called him as an adverse witness. And so it started out with a cross-examination, but Mr. Archer is free to do his direct now during the plaintiff's case. And we had gotten through what we were told would be the last week here of the Smith's rules. So Mr. Morris, if you take the stand, you remain under the oath that you took yesterday to answer questions truthfully. And I will invite Mr. Archer back to the podium to continue his direct exam.
Morning or afternoon, everyone. Ready, Mr. Morris?
Do I just hit got it on the screen to clear
Yes,
this?
it got it. Thank you. Yeah, the white boxes we want to make go away. And, oh, by the way, the touchscreen works now. So, if anyone needs to annotate on screen, mark where the truck was, mark this or that, we can make it happen today.
Okay.
At least that's what I was told. I'd love to try that.
The picture we have up, do you recognize this?
Yes, sir.
What is that?
That's Highway 106, just before New Hope Road with the New Hope Church on the left.
And this is about where the incident occurred.
Yes, sir.
Can you approximate how far New Hope Road is from the location where you found Mr. Shackleford after the accident?
I would say about 150 yards, maybe 200 yards. It's not a long distance. It's kind of right across from the entrance of the church.
So when we're looking at this picture, the New Hope Road that he says he was walking towards is essentially at the church.
Yes, sir. It's probably maybe just I don't know, 10 or 15 yards before you get to the entrance of the church. It's not far.
You said that you left out at about 5:15 a.m. in the morning.
5:15, 5:20. Yes, sir.
Does that give you, were you in a rush? Were you going to make it to work on time?
No, sir. I wasn't in a rush because I only had to be in Athens area, which is Commerce, which is basically about 35 minutes from my house.
And what time do you need to be at work?
7 o'clock.
Have you driven to the Athens area, the Commerce location that you were going to? Have you driven to that before in your bucket truck?
Yes, numerous times. I used to work a lot of shifts in Athens, so usually once a week I would drive that route.
When you've driven on 106, do you see pedestrians on a regular basis?
No.
Have you seen pedestrians on 106?
If I have, I don't remember. You just don't. It's not something normal you would see driving down 106.
Are there sidewalks along 106?
No, there's not.
Where in the picture that's before you, on the right-hand side of the road, is there a shoulder?
There's a grassy area, yes.
And that's where Mr. Shackleford was laying after you turned around to come upon him?
Yeah, so that's where I found him, a few feet off of the road laying in the grass.
And could you walk in that area a few feet off of the road?
Yes, sir.
About how wide, if you recall, is that grassy median?
5, 6 feet maybe, at least.
And were you able, when you approached Mr. Shackleford, did you ever walk just in the shoulder? If you remember.
Don't quite understand the question.
Sure.
Like, was I walking in the grassy area? Is that what you're asking?
Yes, sir.
I did walk over to the grassy area and I did approach him through the grass. I was off the roadway.
We've talked about the sequence of events where you came to, that you described yesterday, where you heard the thud of who you now learn was Mr. Shackleford, right?
Yes, sir.
And will you give the jury a sense of how quick that was, starting from when you first perceived the silhouette through the thud? I mean, what are we talking about in time?
It wasn't even seconds. To me, it was like milliseconds. It was just instantaneous. I really couldn't give you an actual time, but it's not like a minute went by. It's like instantaneous.
Like as fast as clapping your hands once?
Oh, yes, definitely.
And where were you looking just before when you perceived the silhouette? Where were you? Where was your head aimed?
I was facing straight out.
And you saw the log trucks coming?
Yes, sir.
Did you turn your head to look away from the road to look at the log trucks?
No, sir.
When you saw the silhouette and then heard the thud, how did that make you feel?
I panicked. I didn't know what it was. Didn't know what I hit. Thought it was a person, and it freaked me out. I was going through my mind, like all kinds of stuff was flashing through my mind as far as, what's the safest thing to do? Do I stop here? What do I do? And then I remembered, hey, there's an access road. Let me turn around. And because I knew I couldn't see behind me, so I needed to be able to see. So, I mean, just all kinds of stuff were going through my head.
Were you worried?
Yes, I was worried.
Were you worried about your job?
No, I was not.
And you say you turned in the access road. If we can put that picture up again of the church.
While we're waiting for the picture, I've
Yep.
got a quick question. How is it that you knew the vehicles approaching you were logging trucks as opposed to a tanker truck or a lowboy, whatever you call the thing? But why?
They run a flashing light in dark on the end of the logs, so you can see them, and I could see the flashing lights coming.
Okay.
And so
On the tail, I'm sorry to interrupt you, but it's way on the back of the log truck that has that flashing light.
correct, and you could see it flashing, and I knew it was a big truck coming, and they run up and down that road all the time.
So from experience and that flashing light led you to believe it's not just any truck, these are log trucks that are coming.
Correct.
So the access road you were talking about, first of all, there was some, go ahead.
Hit stay muted, it's done pop something. Okay.
Let's try out the touch screen. If you can.
All right, so here, let me navigate you through this. So tap the screen anywhere you want. And then is there see that little pencil that came up? Tap
Yeah.
that when it's up. Now your finger, just do a sample over it right there. There you go.
Okay.
Does that show up?
Yeah.
Excellent.
So will you?
It's a big one. You don't need a lot of precision.
No, we don't. Well, he's got big truck driver fingers. Will you point to where the access road that you turned down?
The access road is right there.
And why did you turn down the access road as opposed to stopping and walking back or backing up or doing something else? What was your thinking on turning on the access road?
So to start with, I didn't know exactly what I'd hit. Second, I couldn't see behind me. I don't have lights that shine behind me. And I didn't know how far past where I struck the object. I didn't know how far back it was. And I needed to see. And so I turned around in the access road so I could go back and see if I could see what I'd hit. And that's just what I did. I thought that was the safest thing to do.
And then you turned back down towards Mr. Shackleford?
Yes. So I come back up the access road, which dumps out behind where the incident happened. And I turned back going south again. And I used my spotlight to shine to see what I had hit.
Okay, you're talking about a spotlight. Explain to the jury what your spotlight is.
So my spotlight's almost like a police car, has a light that's mounted to the door that you can operate from the inside. So I took that spotlight and turned it on and was shining it from the middle of the road to the edge of the road looking.
And are you using your headlights as well?
Yes.
And you then see Mr. Shackleford?
I see him laying on the side of the road, laying on his side, waving his hand.
What did you do?
I stopped the truck, I kind of pulled the truck over to give as much room as I could for the yellow line. And of course, I've already had all my flashers on because I was driving real slow looking. And I parked kind of off where my tire was sitting on the white line. And I hopped out and run over there. And then I told him help was on the way. I'd call 911 as soon as I got out of the truck.
And so how did you feel when you confirmed that the silhouette you hit was a person?
I was a nervous wreck.
Then what happened?
Basically, car approached and checked on Mr. Shackleford. I stepped back out of the way, and it seemed like a long time, but the ambulance and the sheriff's deputies and all that they came right on, but it seemed like an eternity.
Now, you said a car approached and checked on Mr. Shackleford. You checked on Mr. Shackleford or someone in the car did?
Someone in the car did. I actually just kind of looked at him and he was holding his ankle, and I just told him help was on the way. And like I said, a car pulled up and she asked if she could be of assistance. And I said, yes. And she was checking on him. And I stepped back out of the way because I'm not I don't know a lot about medical. I'm trained in first aid. If somebody's bleeding to death, I can put a tourniquet on or I can do CPR, but I don't know anything else about medical. So I just figured it was best I just step back.
Do you know, did you ever get a name of that woman who stopped?
I did not, and it got so chaotic real quick that I didn't see it. She just kind of disappeared. I don't know where she went. I guess she got in her car and left, but it got pretty chaotic around there pretty fast.
And did you perceive any injury? What injuries did you perceive, if any, on Mr. Shackleford?
The only thing I noticed was he was holding his ankle. That's pretty much all I saw was him holding his ankle. So I didn't know. I figured, well, okay, well, he's got a lower leg injury. I didn't know if he had anything else at that point.
Was he conscious, if you could tell?
Yes, he was.
What did you see bleeding?
I did not.
Did you see disfigurement on him?
I did not.
And law enforcement came
Yes, sir.
and emergency vehicles?
Yes, sir.
Did you stay and talk to everyone?
I talked to the law enforcement. I didn't talk to anybody for EMTs or anything. I just stayed out of the way.
Did anyone inspect your truck?
Yes, sir. DOT, and well, the law enforcement, sheriff's office and then state patrol walked around and looked at my truck, but DOT come out of Gwinnett and they went over the truck, check brakes and everything, lights.
What happened? How quickly did Mr. Shackleford leave the scene? He left in an ambulance, we've heard.
Time wise, I don't really know. It wasn't very long. I know they got there and they worked on him a minute and loaded him up and was gone. It maybe 15 minutes from the time they got there. It didn't take them long and they got out of there.
Now, you've testified that you lived in Toccoa about 20 years before this incident happened, and you heard Mr. Shackleford say he lived in the Clayton and Toccoa area. Before this incident, did you ever know him?
No, sir. I've never seen him before in my life.
What happened after he left? Did you drive home? Did you have to go somewhere? What happened?
We stayed right here in the roadway for, I know, at least an hour. And then State Patrol moved us all over to the access road. And we stayed over at the access road until DOT got through inspecting the truck and filling out paperwork and all that stuff. And then my supervisor took me to Habersham Medical Center to get a drug test.
And do you know why you got drug tested?
Any commercial vehicle, anybody involved that has a CDL, if a pedestrian or a person has to go to the hospital, where it's a car accident or whatever, or a car has to be towed, there's certain stipulations. Automatically, the CDL driver has to go get a drug test.
Do you know the result of that drug test?
It was negative.
Do you use drugs?
I do not.
Do you take medicine?
I do not.
No medicine at all?
No, sir.
Do you drink?
I drink a beer occasionally. I usually drink it if I eat supper, me and my wife go out, but I don't have a refrigerator full of beer at all. So it's just like if we go out to eat supper or something.
Did you drink on Sunday, the 11th?
I did not.
Did you have to have time off at Georgia Power after this incident?
They just let me go home for the day just because of just the traumatic situation. They didn't want to put me back in the truck driving that day, and I came back to work the next day.
And when you came back to work, this would have been on the 14th. You took the 13th off.
I took the rest of the 12th off. I came back on the 13th, I think. I think it was 13th, but they only give me the rest of the day off because that happened in the morning. I think we were wrapped up drug tests and all by lunchtime. And so they said, hey, just go home.
And so you were back driving the next day?
Yes, sir, but it was later on that evening because my shift's a 3 to 11, so I came in later that afternoon.
Have you ever been disciplined by Georgia Power for this incident.
No, sir.
And you're still driving a bucket truck for them.
Yes, sir.
Same size bucket truck?
Actually, the truck I got now is a little bit bigger. It's a 4-wheel drive. That one was a 2-wheel drive. So it's actually a heavier truck, a bigger truck. It's still, they've done away with the TA40s, which is like what was on the video screen. They're doing away with those trucks. That truck got decommissioned 2 years later. And I guess 2 years. I just got my new bucket truck about a year ago. And they've went to an AT45, which is a bigger truck.
So do you remember about what year you got sued off of this? Is it a couple of years after?
As far as I got served, like they served me the papers at the house.
Or the suit got brought? Yeah.
I don't remember the exact date when it came. I remember going to the door, opening up, and there's a sheriff's deputy standing there asking, "You Mr. Jason Morris?" And I was like, "Yes." And he's like, "You've been served." And I've signed paperwork. And I'm like, "What is this?" So I don't remember the exact date when it was.
But certainly from that date forward, you've been thinking a lot about this incident.
Yes, sir.
And you thought about it before you got sued?
As far as getting sued,
Or before the lawsuit?
before the lawsuit, I mean, concerned about what happened, but didn't know what was going to eventually take place. I didn't know if anything was going to take place. Didn't really know.
So as you've reflected on it and listened to testimony and thought about the incident, is there anything that you can think of based on your experience that you would have done differently on the morning of August the 12th?
Absolutely not. I think I've done everything that I could have done that saved my life, the truck driver's life, the log truck driver's life, and Mr. Shackleford's life. I think I've done everything I could possibly do.
And even though the truck obviously struck Mr. Shackleford, do you believe you avoided him?
I do. I completely believe I avoided him, because if I'd have squared up on him, this would be totally different right now.
Squared up on him, like intentionally targeted him?
No, like if I hadn't have jerked the wheel and maintained where I was, then the truck, the front bumper, the right tire and everything would have run over him.
So if the truck had not veered to the left when you pulled it, if it had just stayed straight, then that's what you mean by squaring up?
Yes.
I have nothing further on my direct, Your Honor.
Okay. Do you have any recross?
Yes, Your Honor.
Just a handwritten.
Mr. Morris, good morning.
Good morning.
We talked a little bit yesterday afternoon. Do you remember we talked about this? I believe you said there was this handwritten statement that you had written. It was the day of the accident, right?
Yes, sir.
I believe your testimony was that you put this together right there at the side of the road. You know, would you say like within an hour or two of the accident, or?
Yes, sir. Within an hour or two. I mean, it was by the time we moved off the side of the road, I was standing in front of the bucket truck.
Okay. And your testimony was that this was because if you remember, I showed you a typewritten statement. Do you remember that?
Yes, sir.
Okay. And you looked at it and you said, "Hey, this sounds like what I said, but there was a longer handwritten statement that I put together." Do you remember that?
Yes, sir.
Okay. And I believe you said that you wrote that handwritten statement, then you had not seen it since.
I had not.
Okay. Did you have occasion to get to see it this morning or last night?
I looked at it just briefly, just to verify that was my handwriting and that was the statement.
Okay. And Mr. Morris, I'll represent to you, we got it for the first time last night,
I understand.
your handwritten statement. I'm going to hand you up a copy of it. I may actually need to borrow those second copies. Do you recognize, I guess my first question is, that you recognize any portion of that as being your handwritten statement?
So this first one that you just handed me is not, because I don't I don't know whose handwriting that is,
Okay, so
because I write sloppy, so.
Okay, fair enough. I just want to make sure I understand. So that first page that we're seeing there is not your handwriting.
That's correct. I don't know who wrote this.
Okay, fair enough. Flip over to the second page with me, please.
Yes, the one that's got 605 up in the corner.
Okay. That one is your handwritten statement, right?
Yes, that is my handwriting.
And I'm going to hand you the typewritten one that I gave you yesterday to look at too, so you kind of have them side by side. Now, once you did the handwritten statement, I think you said you didn't have anything more to do with it, right?
No, I turned it in.
So, someone, not you, took that, you presume, took that handwritten statement and typed it up into the.
I assume. I don't know. Like I said, I don't know where this one come from because I didn't write this other one.
Okay. Reading down through it, does your handwritten statement appear to have been, the substance of it was captured in the typewritten statement?
So the only difference I see in the type statement and my statement is the type statement says Highway 106 past ED, past tense, 2 log trucks. On my handwritten statement, Highway 106 South passing. I was in the process of passing 2 log trucks. It doesn't mean I'd already passed them. That's why I said yesterday, I didn't write this in here because that was not my statement.
And neither in the handwritten statement or in the typed statement, is there anything about, I understand your testimony is first log truck passes, I swerve to the left. Second log truck is coming, I swerve back to the right. That level of detail that you described for us here yesterday is not found in the handwritten statement or in the typewritten statement, is it?
No, I completely understand. Yes.
Okay.
Other than it says I swerved to miss him. Both of them say I swerved to miss him.
Okay.
But I didn't go in great detail of, they just, I mean, I don't think too many people's going to understand, but at this point, I mean, a few hours has passed. I'm a nervous wreck, and then they tell you to write down what happened. You're trying to go back through your mind, everything that happened. And I captured as much as I can on the handwritten. Like I said, I don't know where the other one came from.
If to the extent there's any discrepancy between your handwritten statement that was written within an hour or two of the accident and what you recalled as you were testifying yesterday, would you trust what you wrote an hour or two after the accident versus what you said just yesterday? More than 3 years after the accident?
I would say they're both about the same.
You think they are the same?
I think they're pretty close to the same.
Okay.
Only thing is omitted that I swerved and I did cross the yellow line. That's the only thing that was pretty much omitted that I see in this.
And to be clear, you turn to the left, then you turn back to the right. When you turn back to the right, that's when you heard the thud, right?
That's when I perceived that I heard the thud. That's what I'm thinking, but it was all seconds, like milliseconds. I don't know. It did not take long.
Mr. Morris, would you agree that if you focus too much on one object, it can diminish your peripheral vision?
Yes, if you focus on something, yes, you're going to become tunnel vision.
Okay. And your testimony here today is that your attention was on those approaching log trucks, right?
I was not 100% focused on them. I mean, I didn't develop tunnel vision. I have to keep an eye out on what's coming.
as you approached the scene of the eventual accident, your attention was on that left lane and those approaching log trucks, right?
Not really attention on them. Yes, I perceived them coming and I stayed in my lane and I was in the process of passing them. But no, as far as just dead focused on them, I was not dead focused on them.
Okay. You still have your deposition?
I do not.
Okay. We have another second. Oh, is it still here? Okay, thank you. Mr. Morris. Mr. Morris, asking to turn to page 67 of your deposition. Starting with line 18. And let me know when you get there.
67 line
18.
18.
Are you there?
Yes, I'm there.
As the question was, as the lumber trucks are coming by you on the left, is your attention on those lumber trucks? And what was your response?
And I said, my answer was, I would say, yeah, for the most part, I got two big trucks approaching me, which is still not, I didn't get tunnel vision. I didn't just say, I didn't lock it down on them two trucks. But yeah, I mean, I have to pay attention to what's coming towards me.
In fact, you had so much attention on those lumber trucks that, as the judge asked you a moment ago, you even saw the little light blinking at the back of them, right?
I seen the light blinking from a ways away and I already knew what was coming because that's what runs up and down that road.
Mr. Morrison, your experience as a bucket truck driver, is it more important to pay attention to the other lane of traffic coming against you or your own lane of traffic?
You got to pay attention to both. It's not one's more than the other. You got to pay attention to your lane and the other lane. I mean, I don't know what them trucks are going to do. I mean, they very well could fall asleep and run across the line, and I have to be prepared to make evasive maneuvers. So yes, I have to pay attention to them and my lane at the same time.
On your direct examination, I believe you testified you've gone by log trucks hundreds of times, right?
I do.
And I think under my questioning, he even said you weren't too concerned about moving over to the right at all, just because there was a lumber truck coming the other way, right?
That's correct.
Now, you mentioned a minute ago on direct, I think you described the accident as kind of happening instantaneously, I think was your description.
Well, I mean, when it happens, it feels like it's instantaneous. It might take a little longer, but I mean, to me, it was so fast. I mean, there's not a lot of reaction time.
And I can't remember if you addressed this on direct, but I don't think there was a mention of it. You didn't sound your horn at any point in this process.
I didn't have time to sound my horn.
Now, you talked a little bit about once you got to the scene and you got a chance to see Ron, and you described your perception of his injuries at that time. Now, you've had a chance to be here through the whole trial and hear his description and other evidence. At this time, do you have any reason to disbelieve that Ron sustained a serious injury to his left foot?
I do not. Like I said, I mean, I'm not a medical professional, so I mean, if the medics and the hospital said he has a serious injury, he's got a serious injury. I know he was grimacing a little bit of pain when I was there, but I'm not a medical professional, so I didn't know exactly what was wrong with him.
At the very end of your testimony or your direct a minute ago, you mentioned something about if you had not veered to the left, you would have hit Ron kind of squared up or head on.
I wouldn't call it head on. He would have been square with the front right of my bumper. So basically the bumper would have caught him, the wheel would have caught him. I don't know what else would have caught him. He would basically probably been drug up underneath my truck.
You heard the thud after you turned it back to the right though, right? Correct.
As far as I remember, yes.
Okay, that's all I have at this time. Thank you.
Do you have any redirect based on that, Mr. Archer?
No, Your Honor.
Okay, I've got one question. You may want to follow up on that after I ask it. We'll see if the jurors have any questions. I'm trying to figure out, from your recollection and perspective, how it was, you could see, I get part of the answer. You can see these large trucks coming from far away. They've got headlights, so you see that. How was it, as you think through this, that the silhouette that you saw, you really only saw at the last second? If your headlights are trained however many feet out ahead.
So I couldn't see the actual logs. I couldn't see the trailer or anything, but you could see the flash. They have a bright flashing light on the back, and it's an amber.
Yep.
And so I knew it was a truck coming because of the lights on top of the cab.
Yep.
And then I could see them flashing, and there was two back to back, and they run that road all the time. So automatically was like, here comes two log trucks.
Yep. I didn't ask my question well. You explained that before. I'm trying to figure out how the silhouette to your right was so imperceptible until the last second, if in fact your right front fender, which is where your right headlight would be, was right there. So I was contrasting that with the truck lights, which you saw from far away, but I get it, they're flashing, and the silhouette doesn't have a flashing light on its head. But it sounds like you said if I had squared up, this is what prompted, if I had squared up, that right fender would have hit what turns out to have been Mr. Shackleford, not that you knew that. How is it that it was only at the last second that you felt that you saw it, if it seems like it would have been in the beam of your headlight?
I think I understand what you're asking. So when I say squared up, I'm saying if I hadn't, I understand where you're getting at. Like I should have seen all of him with the headlight,
I'm
but
not getting at anything. I'm not saying should have done anything.
Right.
I'm trying to figure out how it was just this brief silhouette to which you reacted and if you hadn't reacted, what I've heard you say is my right front fender would have hit him.
So
Why wasn't he more in your line of sight because of headlights? If he was so much out in the road that your right front fender would have hit him.
So basically, and I apologize. I don't want to go back to the 5 keys. I really don't want to, but
Actually ties everything together.
but one of the 5 keys is keep your eyes moving, and which is we have to scan our mirrors every so many seconds. And so basically this mirror straight forward. I mean, you're constantly back and forth. So with that, my only explanation is I was probably in the process of scanning my mirrors and I caught a glimpse of him when I was coming back. It's not like I could see way out, but like I said, I apologize for 5 keys. I really don't want to.
There's a reason you learn those things. Did you have any follow-up based on that?
No, Your Honor.
Mr. Archer?
No.
Okay, great. Jurors, any questions for Mr. Morris? I see some cards. Deputy Gordon gets roused up. He's gonna come collect those. Thank you. All right, let's try this thing. I'll hustle over to that office.
Ask you a question.
Up on board to King Home Artist today. It's there. This there, like through the. What's there? Okay. I went. Which security?
The long hallway?
Yeah.
Oh, so you can recall from government. building.
Yeah, I came to the government building. And then. Got up. Walk that way, so I walked that way, another security. guess that maybe someone can come down and we'll drive here.
No, you're good.
Trying to reach your free lunch.
Yeah, my wife might get mad if I lose her glass Tupperware. I know. Mhm.
My husband did say.
So I don't care about the food. Just the container.
That's been bothering you when you came in yesterday morning for security. See it. That was kind of like a lunatic. Like, and then it was not the area that I went through, but it was put it on the next one. That wasn't used.
At least they found it, yeah. Yeah, they gave me all sorts of problems. They made me take this, they said this was a jacket, I had to take it off. I was like, oh.
Ready?
I'm ready.
All right.
Yeah.
Do you typically wear glasses while you drive?
I do not.
Were you wearing them on the morning of August 12th, 2019, when the accident happened?
No, my glasses are just for reading. I can see distance real good.
How long does the trip from your home to that Commerce Athens destination typically take?
About 35 minutes.
Did you stop anywhere from the time you left your house to when the accident occurred that morning we've been talking about?
I did not.
About how far away were the log trucks when you first perceived them, whether it was the flashing light or the headlights or whatever?
If we went back to the picture where I drew on, they
Put
were,
it up. Can we put up the one that has the church way off in the distance?
yes, sir.
Right.
So let me see.
You may have to reactivate it, but you're a pro now.
Oh, I don't know about a pro. So I saw the first log truck right just past the New Hope entrance is where I saw the first one.
Okay. And you obviously weren't right there because you were moving.
No,
You
I
were
was
further
back here, but it was about right in there where I first perceived trucks coming. I could see a flashing light.
Okay. Can you explain to the jurors, please, how it works physically for you to swerve left to avoid the silhouette, and yet it's your right front tire that hits them? Does that question make sense?
Ask it one more time if you don't
Sure.
mind.
You're driving down the road, you perceive the silhouette to your right, as I understand your testimony.
Yes, sir.
Evasive maneuver, you swerve to the left, pulling your right front tire away from the silhouette. And yet it's the right front tire that it sounds like is what struck Mr. Shackleford. So the jury's question is, how physically does it work that you are pulling your right front tire away from the silhouette, and yet that's what hits the silhouette?
So basically, I don't really know how that works, to be honest with you. You jerk the wheel. I don't know if it hit him when I pulled it right back, or as soon as I pulled it, I don't know if the tire turned and he was, as he said, he was jumping out of the way. I don't know if it caught his foot then. Best I remember, I heard it right when it was just like that, pretty much coming over the line and going right back. And so I don't know if it caught him when I was pulling away or pulling back. I just remember hearing the thud, and I mean, I can't explain it. That's the best I know to explain what I think happened. But I don't know whether it was as soon as I jerked the wheel to the left or right when I started coming back. I don't know which way it was, as far as, I don't know if it caught him first or caught him second.
Mr. Ramsey, do you have any other questions for Mr. Morris based on the exchange he and I just had?
Just one question or possible set of questions, Your Honor, regarding the timing of the thud. Mr. Morris, I thought, I was just trying to make sure we were clear. When did you hear the thud? Was it as you're turning to the left or as you're turning to the right?
It was in the midst of peeling to the left. Like, I don't know if it was as soon as I had gone across the line and started coming back, but I heard a thud. And like I said, I don't know, because I come back instantaneous. As soon as I went across the line, I come back.
Okay, let's just for some clarity, look at page 69 of your deposition.
Okay.
Page 69, starting at about line 20.
Yes.
And we asked you, the question was, when did you hear the thud or the thump? And what was your answer?
As soon as I pulled it back.
Okay. And then the next question is, so you had already swerved over and it was when you were coming back and your response was?
Yes.
Okay. Does that refresh your memory about when you perceived the thud occurred?
That's when I perceived it. But like I said, I don't know when and what part of the tire hit him. So I don't know if it was, I perceived to hear the thud when I was coming back, but whether it caught him leaving or going back, my assumption was it caught him coming back.
And your perception was that the thud came from the front part of your vehicle?
Yes.
Okay. All right. That's all I had.
Mr. Archer, any other questions for Mr. Morris?
Yes. So when you swerve to the left, your right front tire, which is the tire everyone is the tire that Mr. Shackleford says struck him, the back of it would face towards him, right?
Yes.
And this is your truck. This is the left tire, but the right tire looks like it. Is that right?
Yes, it's just like it.
How high is that off the ground?
It's probably 3 feet waist high, something like that. It's a good 3 feet high.
I think you said, how much does that truck weigh?
Straight from the factory with no tools on it, it's about 33 to 35,000 pounds, loaded down with all the tools on it and all the material and everything. It could jump up to 40 or 50,000.
And that front tire, there's a wheel in it, right?
Yes, sir.
And what's the wheel made of?
The steel wheel, you got the steel wheel and then the tire mounted to it.
So how much does just the tire weigh and the wheel? Estimate.
Tire and wheel, 300 or 400 pounds.
So if that right front tire ran over his foot, what do you think the injury might look like?
If that front tire ran over his foot, I would expect.
One second, stop.
He's asking about what injuries would look like on his foot if it's run over by a tire. I don't know that's almost asking for medical testimony, Your Honor. And
So what's your objection?
it's asking opinion testimony of a non-expert in that particular field.
More speculation?
Yes, Your Honor.
I don't think it's speculation. He's described the side of the tire. He's experienced with the truck. He's a human and he knows if that tire ran over a foot, what you might see as a result. I'm not asking him to tell us exactly what bone would be damaged. I'm just saying, what do you think the extent of the injury would be based on your experience and the size of that tire?
Have you seen someone's foot that was run over by a bucket truck?
No, sir.
Different question.
All right, nothing further, Your Honor.
All right. Mr. Morris, thank you for your time. You are free to resume your seat at council table.
Thank you.
Next witness, Mr. Ramsey.
Your Honor, are we at a point we can take just a brief break so I can get the video set up?
So we really aren't, and
And we can recall, and we can recall if that's more appropriate.
Okay.
Okay, we will recall Mr. Shackleford at this time, Your Honor.
Shackleford, come on up, please. So we're gonna swear Mr. Shackleford back in because he completed his testimony before, just so the record's clear. Your face, Deputy Jordan.
Please swear or affirm that the testimony you will give in the truth, the whole truth, and nothing but the truth so
Yes.
help. Lord, you have a seat. State and spell your name for the record.
Ron, good morning.
Morning, Chris.
Still afternoon.
Oh, sorry,
Afternoon.
my internal clock is off. I'm sorry. Ron, I don't, as I think back, I don't think I asked you this before, but how old are you?
I'm 48.
Okay. Now, Ron, we talked about when you had your accident, you were taken in the ambulance, you were taken over to the hospital, right?
Yes, sir.
Okay. And what's your understanding, in terms of, were there any tests they ran on you or anything they did that to determine what kind of state you were in, that sort of thing?
Yeah, they took a blood test and for alcohol and
Okay. You said that they did check, they checked to see if there'd been any evidence of you having alcohol.
yes,
Okay. I think you also mentioned that they put you on some painkillers as well.
yes,
Okay. In your understanding, prior to giving you some painkillers, they're going to want to know whether you had any alcohol in your system, right?
right.
Okay. This is the same exhibit we were talking about before. I'm just going to hand it up to Mr. Shackleford to identify what it is.
Okay, this is the exhibit for which you received the certification recently.
Yeah, well, we didn't just receive the certification recently, Your Honor, but this is the one we talked about prior to.
It's the excerpt from the medical records.
Yes, Your Honor.
Okay, we had left unresolved, I thought, because I hadn't heard back from you, the question of redactions. You are not opposed to leaving it unredacted.
So that actually makes it easier on my end, Your Honor, so.
Okay,
I'm fine with
so
that.
I think we are on, let's go, you use letters. We're on F.
Yes, Your Honor. Yeah.
So, Mr. Archer, any objection to the admission of plaintiff's F, which is the unredacted, is it 2 pages?
Yes, Your Honor, two pages of records, and then the third page is the record certification.
Any objection to the admission of plaintiff's F?
No objection to the admission of the document.
Okay, they're admitted.
Ron, I'm going to hand you what's been marked as F. Do you recognize what that is? And Ron, I just want you to just help me understand just help me and the jury understand just generally what this is.
They're documents from Stevens County Hospital.
Okay. And you mentioned that you did get a blood and alcohol test when you went to the hospital.
Yes, sir.
Okay. And you mentioned in your testimony earlier that you hadn't been drinking anything that night, right?
Yes,
We'll flip over to the second page. And do you see there about a third of the way down, it says alcohol-ethanol blood, you see that?
yes,
Okay. And right under that, there's a line that says alcohol. And then if you kind of track it over to the right, you see there's a number there,
yes.
or a symbol and a number. Can you just tell us what that symbol and number is?
0-20.
Okay, okay, backtrack a little bit. Just go back to the left a little bit.
Oh, the milligram,
I'm sorry.
milligram, slash,
Okay. Go a little bit more to the left, I'm sorry.
10.
Okay, and actually there's a symbol beside that. Did you know what that symbol means? In math terms?
I do not.
Okay, okay, fair enough. All right. Your Honor, quick point of housekeeping. I was going to let Mr. Shackleford speak to the medical bill summary. Right before we got started, there was a mention that my math may have been in error. I don't know if.
So this is your time to work with Mr. Shackleford. You may want to highlight the math mistake if you think there is one to
Okay.
indicate it will be corrected, but
Right.
now's the time to work with Mr. Shackleford.
And Your Honor, by agreement, I believe we've stipulated this is going to be substituted as the new first page of exhibit was it D, I believe? Yeah.
Yes.
Okay.
With the corrected math, if it needs a correction.
Yeah, I think I checked it twice last night, so I'll stand by my math, and if I'm wrong, I'm wrong.
You tender what you tender, and
All right.
then Mr. Archer can do with it as he sees fit. So this is the new first page of plaintiff exhibit D.
New first page of D. Mr. Shackleford, I'm gonna hand this up to you. And take a look at that for us, and I'm not asking you to necessarily double check my math, but could you kindly just read through that list of providers and amounts and dates?
8, 12, and 19, Stevens County EMS, $667.32.
And Ron, time out. I'm sorry. I just wanted you to kind of read it to yourself and make sure you agree that appears to be an accurate summary of your providers and of your bills.
Yes,
Mr. Archer?
I am happy to, we'll check the math, but I will stipulate this summary is a stipulation of the medical bills associated with the visits to the hospital as a result of the accident. We don't need to go through it.
No, it's already in evidence, in fact. So if you want to publish it, you can publish it.
That's what I was.
Held back because of a.
Because of that one.
redaction that was needed.
Right.
That's occurred. So if you're going to ask Mr. Shackleford any other questions, I'd ask you to get it up on the screen.
Yes, Ron. That's what I'm trying to do. I hit the share button and it's just not cooperating with me for some reason.
I don't see you on the call on the
Maybe.
Zoom session. That may be one thing
That's-
holding you back.
That's probably my, I apologize, Aaron, my
Do you
issue.
have the meeting information? 'Cause I'm
I-
looking at who's in.
We'll put it up.
Thank you, thank you.
Sure.
Oh, okay.
Well, and
He's offering, but they don't have it.
Yeah. Well, Your Honor, let me ask this. Is there a new Zoom link I should have, like, in other words, is there a new one for each day or should I just go? That's where I must have messed up.
Push that out to everyone.
Okay, that was I must have missed that. Here it is. Okay. My mistake. And that's probably the issue I was having with Barito a while ago as well. Okay. My apologies, Your Honor. I was using the wrong link.
You're in.
I'm in now. Okay. All right, now we'll mute that. Now I'm going to try to share screen. Go through. Here we go. All right, and no, obviously we'll make that a part of the actual physical exhibit as well. But Ron, this is the same thing you have in front of you.
Yes, sir.
The new first page of Exhibit D.
Mhm.
Okay, and if you add all those up, those total up to $25,931.39.
Yes,
And it's your understanding those are your past medical bills that you've had related to the accident that you had.
yes, sir.
Okay. Are you still seeing any doctors of any sort for anything going on in the future?
Yeah, my knee's giving me problem in my ankle from
Pause for 1 minute, Mr. Shackleford. Yes, sir, Mr. Archer.
I think that it needs to be specific to future related to this incident, knees and the like.
Sure.
And the way you
objection
actually,
is relevant. I'm just making it up. If he hurt his pinky playing basketball
Oh,
in
yeah.
high school,
Yeah.
probably not related to the freight liner.
Okay. And Ron, we just want to know, just for purposes of today, what are you still getting any ongoing treatment for the issues with your left foot?
yes.
Okay, and what, how often do you still go to see a doctor for that sort of thing?
One I go to once a month, and I got an appointment, I think in 6 or 8 weeks.
Okay.
To get it checked out, and he was talking about having some boots or shoes that I can wear, because I got a pair of lace up Justin boots that I tie up tight, and it keeps my ankle kind of stable, but the bending in my foot is what really gives me a hard time.
Okay. All right, nothing further at this time, Ron. Thank you. Please answer any questions council may have for you.
Okay.
Did that bring up anything for you?
yeah, just, and I'm gonna approach just to maybe show the document and move this along.
Sure.
I just have a couple of questions about this thing that you say is an alcohol test. I'm looking at the second page. First of all, did they test you for anything? You said they tested you for alcohol?
Yes.
Did they test you for any other drugs?
Yeah, it was, they called it something, some kind of scale, and they drew blood, and that's all I know of it.
Okay, and you, for Mr. Ramsey, you were reading part of this. Will you read this line right here after categories? What's that say?
It says, alcohol, ethanol blood / 8 or 8/12/2019,
And then the last.
10:22 a.m.
And will you read this line? Beginning with those two letters.
The SH,
Mhm.
Smokes, drinks alcohol, no drugs, and lives with family.
Okay. What was the court reporter needs that last phrase?
Lives with family.
You left the girlfriend's house at about midnight on the 11th, right?
I didn't have a watch. That's like me asking you if golf game you played 3 years ago or 3.5 years ago, what time you started, what car did you use, and how your golf game went. And it's something you don't, I have no way of really taking.
Understood. By the time of the accident, you'd been at around 6, you'd been walking for approximately 6 hours. You'll agree with that. That's been your testimony.
Yeah.
And then you get to the hospital a couple hours, you get to the hospital later than that, and then they do the tests later than that.
They give it to me at Stevens County, I believe.
After you got there and they
Right.
bring you in, and then later they do a test.
Yeah, and they also done a test at Athens Regional.
Okay, but this is what we've been looking at Stevens County Hospital, right?
Okay.
Yeah, nothing further, Your Honor.
Nancy, anything else?
No, Your Honor.
Okay, did that prompt any questions from the jurors? Oh, all right, Mr. Shackleford, thank you.
Thank you, Your Honor.
So now that you've figured out the connection.
That might be the issue.
Shift, we won't get all the way through.
Right, we can break at a
We'll
good
break
time.
at some point during it, but we've been going only for about an hour, so I'd like to hold off a little bit on the break. I don't see any frantic waves from the jurors, so let's get that going. Remember to check the little boxes in the corner, lower left-hand corner when you're sharing the file.
That's not it. Mr. Ramsey. I'm trying, Your Honor. I can show a PDF easily or a Word document, but for some reason on a video, it's not popping up for me. It's not given that even as an option that I can share. I mean, I have the video pulled up. It's showing on my laptop here, but it's just not showing on the.
Okay, do you have any other witnesses?
This
is your last witness.
This will be our last, yes, Your Honor.
Okay, well, we'll take our break early and you will have 10 minutes to make it work if you're gonna share this video deposition with the jury.
Thank
Ladies
you.
and gentlemen, I'm gonna ask you to take an early break. That may mean we have to take a short break as we approach the 6 o'clock hour, if we're still going then. Just to take care of everyone's stamina. During this break, we'll talk about the case, no outside research, enjoy the jury room and the outside view. And we have a guest deputy here who's going to get you. Do you know where the jury room is?
I'm guessing it's right here.
It's right there, you're guessing right.
All right, so the jury. How you doing, Judge?
I'm doing well, how are you? Thanks for getting Deputy Gordon out of here.
He's coming back.
Uh-oh.
Yeah.
Yeah.
Maybe.
Hold on, well, let's just, before we wrap up, anything other than prayers for the technology guys for you, Mr. Rams, before?
That's much appreciated, Your Honor, and I apologize. That's not my strong suit. That's the only thing, obviously all my attention's on that right now. So
Okay, Mr. Archer, anything before we go off the record and start the break?
Nothing, Your Honor.
All right, thank you. Now you can see if they can.
Yeah.
Ms. Hughes, if you could be back in about 8 minutes, that would be great.
Oh,
Thanks.
wow. But anytime you can't hear me, just let me know. We're getting better at this technology thing, so
No worries.
enables us to
Wow.
take this from quite a far away. So we appreciate your time this afternoon. Could you please state your full name for us, please?
Yeah, Jason Tyler Barito.
Okay. And Dr. Berto, can you take us through?
Sure. You just run it from your.
Yeah.
That's right.
I'm not sure what's going on with mine. I can show other documents, but when you hit the share screen and then it goes to the different options, it's just not one of them. Through all that to get his video and then can't play the darn thing.
If this was the front of the truck, and I was thinking the tire.
Fresh one, okay. Thank you. Oh, thank you. No, I'm good. I'm good.
Like how the in the truck and where the tires stick up under the fender.
Yeah. I don't want you to talk about that in front of people, okay?
Oh, sorry.
That's all right. Whatever you want to tell me, just tell me privately.
Okay. Sorry.
That's okay.
Can I walk out? Or-
Yeah, I'm gonna
So-
walk for a little bit. Yes, ma'am. Yeah.
The-
Oh, my goodness. This is a disaster area.
Not sure which one to start with, and I do have some clips.
Some of these are not exhibits. We just referenced them. I'll take those out.
It's up there.
Yeah. Take those out. We got E, D, and C, A and B. Yeah, man. I'm just kind of slow.
Yeah, everything I've got down, this is everything that was up there plus one of the trash.
Oh, there it is, there it is. Yep. Yep, so that's all right. I'm good. I'm good grabbing it.
And the replacement of D,
Yes, ma'am.
the first page of D.
Yes, this is that new first page of D.
Up here.
Yeah.
So now, we replace
Oh, thank you. Should have everything. Got
it. It's just like.
All we to do right now.
That's,
This is the-
yeah, no, I'll grab a, do you have an exhibit sticker on there? One? Okay. Okay. Thank you. I want to come check on the exhibits and make sure, I'm doing my best to make sure I put the right pages in and. Let's see, I think through some of them back in.
Can I borrow your towel, Chris?
What's that?
Can I borrow your washcloth?
I've been wiping my face and hands with it. If you want it though, you're welcome to it.
Thanks for the head.
Yeah, I didn't want to, I'm not sure what you were going to use it for.
I don't, by the time you get that.
Oh, they didn't have any hand towels in the restroom?
Dr. Berto, good afternoon. My name is Chris Ramsey. Can you hear me okay?
Perfect.
Okay, wonderful. If at any time you can't hear me, just let me know. We're getting better at this technology thing. So,
No
it enables us to
Boy.
take this from quite a far away. So we appreciate your time.
God has a sense of humor, right? Yeah, I would,
Yeah, that sounds great.
maybe what we can do is start playing it and then have the judge ask the jury, hey, can y'all all hear it okay? And then let them confirm
It's
that.
a little echoey from where I'm sitting, but I think it's just because it's on by the laptop.
Yeah. Okay. The B run off to. B was photos of the accident scene.
Yes, A and B were both photos.
Yeah, I think we threw them in our, okay. Very good.
A was 6 photos and B was 12 photos.
Yeah, let me make sure they all stayed in there. I've got a paper clip unless you prefer your paper
Nope,
clip, that's fine.
No, my hands are not dry.
11, yeah, 12.
About the alcohol, I don't drink, I mean. Maybe a lot.
Mhm. Mhm. Yeah, I don't know what that means. I think they'll know what that means too.
So I have a question. When the judge wanted Mr. Shackleford sworn back in and being able to re-date, do I list that direct examination again or redirect?
Say that again?
We kind of recalled him as a witness to get that last couple things in.
But then he wanted him sworn back in because it had, y'all were finished with it. So do I put that as redirect or direct again?
I would say direct again. Redirect is usually when you've already asked him once and then you're coming back.
But being that this is, they had him sworn in again, just listen as direct.
I'm fine with it being listed as direct. I mean, the characterization of whether it was direct or, I mean, usually the way I think of it is it's direct. The first time I talk to him, then he gets to cross-exam, then I get to come back and do redirect. But then this was this whole separate time he got called up there. So I would say it was direct and then he got a chance to cross-examine him. And then I don't think I had any, I didn't have any redirect.
And the court asked questions as well.
Who?
the court asks questions as well.
Right, right. I'm not gonna get heartburn either way, as long as it's something y'all are agreeable to.
So what would you prefer? What are the choices?
Either put it as direct or redirect.
I'll just go on the record. I'm fine with whatever Mr. Archer wants to do. This is it. This, to me, that's an easy one. I'll defer to him on whichever, however he wants to call it.
Let's call it redirect, just to avoid any confusion that it's like, it should have been earlier or something.
Yeah.
Yeah, that's fine. So on Maloney, just to make sure on the same page, everything I said, hey, I have an objection to that coming in. It's, when you amended it, you took some of those out anyway. And then the ones that I still objected to, those you're agreeing to take out. Okay.
I think you had 3 objections. 2 were the citations, which I took out, which have been taken out already, and 1 was about who's Walton was.
Okay.
And I took out your question on citations.
Oh, yeah. The only reason I was asking about that was, yeah. It's kind of weird. You have to almost anticipate, well, it all might come in, you know, so I got to ask about it. Yeah, I think his ruling is basically, we shouldn't even mention the word citation if we can avoid it. Yeah. Yeah, again, I apologize for not getting back to y'all this morning because I was sitting there blind. I kept calling the hotel front desk. I was like, can I hook directly into some internet somewhere? They're like, no, it's down for the whole hotel. So, I submitted the verdict form and the request to charge. It's the exact same thing I submitted the other day, but they had rejected it because my signature was in the wrong place or something. So you don't have to worry about scouring through and seeing if it's any different. It's the same thing.
I looked at it this morning.
Yeah, it's the same one that I emailed to her on
I assumed it was
Sunday or
just
Monday.
e-file. It's just-
Yeah. I got the nasty gram from the clerk's office, so I had to resubmit it.
Welcome, be seated. Mr. Hughes, are you ready? All right, let's go back on the record. One of the jurors gave a note to
Deputy Thompson.
Deputy Thompson I'm gonna read it, we'll make it part of the record. It's not controversial, but because the juror communicated with the deputy, I wanted you all to know. Ask Mr. Shackleford to speak into the microphone, having difficulty hearing and understanding him when he speaks. Juror number 13. So what I'm going to do is remind the jurors that if a situation like that arises with any witness, let us know then and there instead of with a note after the witness is done. We'll address it that way. Anything, Mr. Ramsey, about that note or about technology and Dr. Barreto that we need to get on the record?
No, Your Honor, again, they're just thankful for opposing counsel and the cordiality of playing it through her computer. So we think we have it addressed, although I make that ironic statement at the beginning that we're figuring out technology.
I heard that as I was walking out and chuckled. I appreciate them being flexible as well on that. We'll make this flow more smoothly. Ms. Peeler, this is the edited version, so you can press play and not worry about having to mute when Dr. Barreto starts talking about the special mid-leg surgery.
Yes,
Fantastic. About how long is it?
it is 46 minutes and 36 seconds.
Not about, it is exactly. Okay, good. Your expectation is to rest after the completion of the deposition?
Yes, Your Honor, the only, just more of a housekeeping question for Your Honor is, as part of our request to charge, we had asked that the, I can't remember which code section it is, but there's the actuarial table or the life expectancy table. And I was thinking that's not really evidence. It's just something that gets, if appropriate, that goes to the jury that they get to look at. So I just want to make sure I don't lose my opportunity to put that in if I need to put it in as an exhibit. I was thinking it'd be more something like a jury instruction.
So the jury instruction says you have in evidence, and it lists these two mortality tables from before I was born. So I don't know how accurate they are.
Right.
But that's what the jury charge says. And I've already flagged that jury charge as, whoa, why are we getting this? I don't have any mortality tables. I don't think it is a judicial exhibit. It would be an exhibit that someone who wants the jury to rely upon it to tender it. I think those types of mortality tables are close to judicial notice since they're named in the jury charge. They must be, maybe because of their age, just accepted as valid science. I don't know what we would call mortality tables, but I leave it to you to navigate how to get those before the jurors. If they're not in the record after both sides rest, I'm going to give a different jury charge because there won't be a mortality table. So you should talk with Mr. Archer and Ms. Peeler about that. I've only had one other trial with mortality tables, and plaintiff's attorney tendered them as exhibits and defense didn't object, but they weren't tendered through a witness because they didn't call an actual.
Right, and that would be our expectation as well. It would just be tendered without the use of a witness. And then again, I've mentioned this to them before we started today, and I don't know if they have, any other objections or whatever to that being used, but
I'll find out in a minute. More fundamentally, do you have those mortality tables?
I would have to pull it up, Your Honor. I have to access it, but again, my recollection was it was a code section, so an OCGA code section, I thought.
Okay, I leave it to you as to how you're gonna get to me those mortality tables that are named in that pattern charge. And we'll work through that if you do that.
Okay.
Ms. Peeler, I'll start with you because it sounded like Mr. Archer had delegated to you exciting things like mortality tables. Do you have any objections should Mr. Ramsey get his hands on these mortality tables to their admission as evidence in this case?
I think they're relevant. We haven't had any testimony about life expectancy or any sorts of it. The only testimony we've had about his injuries are to his foot. I don't know that the mortality tables are relevant to this case. I should they go back to Perry.
Well, aren't they relevant in the sense that we now know how old Mr. Shackleford is? He was asked that when he was recalled. So if he has continuing pain and suffering that the jury thinks he ought to be compensated for because they find George Power to be at fault, there's a math problem for them to do to say it's pain and suffering of $10,000 a year. Because I think there has been some testimony, actually, that in some ways that you all have been seeking, the defense has, that I'm not gonna get this other surgery. I'm gonna deal with my current situation, which, by the way, hurts a lot. So the jury's gonna have to quantify pain or impact it's had on his life or his wife, et cetera. Our life is different. And then to monetize that, they need to do the math of, if it's this way this year, we forecast it's gonna be this way for the rest of his life. There's been no testimony that things will get better for Mr. Shackleford. In order to do that, they need to estimate how long he'll live, hence the mortality. Is that not how Mr. Ramsey would likely argue it, and then that's the way the jury would need to do the math?
The measure of damages is in the enlightened conscience of the jury. I think they can choose to take that into account or also choose not to take it into account. And the second point is I haven't seen the mortality tables and I'm not sure how he's going to get them in, so I'd want to reserve any objections to actually see what he wants to proffer.
Okay, I find that they're relevant along the lines that I described. Assume the mortality table looks like a chart. If you're this old, you're expected to live this much longer. I don't know exactly what to do. There's some kind of chart that helps the jury figure out if you're 49, 48 today, your life expectancy is X. And that lets the jury say, well, that's 30 more years. So if it's $10,000 a year, it's 30 times 10. What more would you need to see? You're entitled to see them, that's not my point. I suspect they're online, they have these names. But what do you envision your objection being?
It depends on the source of the mortality tables, where they're coming from. There has certainly not been a witness who could introduce them as an expert. So I think it would have to be a source that the court could essentially take judicial notice of.
Okay.
To determine that they are reliable for the jury to review.
Got it. So there's some work for you.
Yeah, Your Honor, I would say whatever I'm going to proffer is going to have the OCGA designation for it. I mean, I'm not going to go get Joe's mortality table.
No, I didn't think that. There are two of them and they have names and it's in the draft charge I've sent you all. I don't know whether it is part of the official code of Georgia or not, but you'll need to figure that out. So we'll table that one. It's not out, but it's not in.
Understood.
Anything else, Mr. Ramsey?
That's all for the plaintiff, Your Honor.
All right, Mr. Archer?
Nothing for the defendant.
So let's bring the jury in. I'll explain real briefly why they're looking at a screen instead of a live witness, and we'll go from there.
All right, for the jurors.
Thank you, Deputy Gordon. You have that back. Welcome, be seated. Ladies and gentlemen, two things. One of the deputies shared with me a note that one of you had written about having a little trouble hearing a witness. I'll make sure to remind the witnesses to speak into the microphone. The microphone is in a funny spot where it's mounted. It is off to the side where the witness sits. To speak in it, he or she almost has to be looking at me, which is not where the witness needs to be looking. Not your problem. But number two, more important, if you can't hear what someone's saying at that time, that's a wave your hands around it. Don't wait until the person's done sending another saying, I really didn't hear anything that person said, because we're not going to recall the witness. So it is okay to wave your hand or say, excuse me, or deputy or judge, and we will pounce on whatever issue is. All right. Second point. Your next witness that you're going to hear from, that the plaintiff is called, is a medical professional, and he'll introduce himself in a minute. You're going to see him on that screen. He will not appear live. In civil trials, it's often the case that some of the expert witnesses, doctors and medical professionals, they are deposed in the sense that they have a direct and cross-examination in a conference room somewhere, because it's tricky with their schedules to come down and not be sure when they're gonna be called to testify. They can block out 6 to 8 PM. I'm not doing surgery. I can talk to you lawyers and answer your asking questions. And that's what this doctor has done. Perfectly acceptable procedure. The only difference is you won't get to ask any questions. So I think the name is Dr. Barreto. Get that in the record in a minute. But if there's something about Dr. Barreto's testimony that leaves you curious, that is an itch that won't get scratched, because you will not do any outside research stuff. We talked about, and you can write something down on a note card, but I can't ask Dr. Barreto. This is actually not an interactive proceeding. Someone's gonna press play and he will answer questions from both sides. And we'll see what else is coming from Plaintiff. Does the doctor introduce himself at the beginning, or do you need to explain to the jury who this is?
I believe he does, Your Honor. That's my recollection. Dr. Jason Barreto with Emory Healthcare.
Okay, that's who we're gonna hear from.
Yes, Your Honor.
And that's the next witness you're calling.
That's this gentleman right here. Yes, sir.
Right, let's do it.
Dr. Barreto, good afternoon. My name is Chris Ramsey. Can you hear me okay?
Perfect.
Okay, wonderful. If at any time you can't hear me, just let me know. We're getting better at this technology thing, so
No worries.
it enables us to take this from quite a far away. So we appreciate your time this afternoon. Could you please state your full name for us, please?
Yeah, Jason Tyler Barreto.
Okay, and Dr. Barreto, can you take us through? Tell me, for instance, where you went to undergraduate.
So I went to the College of St. Rose in Albany, New York, and got my undergraduate degree. I then did medical school at Upstate Medical University in Syracuse. I then did my residency at Brown in orthopedic surgery. At Brown, I also did an orthopedic trauma fellowship, followed that by an orthopedic foot and ankle fellowship, and then I've graduated, and since 2014, I've been in practice here at Emory as a foot and ankle specialist.
Okay. So
Excuse me 1 second. Doctor, can I get you to slow down just a little bit
Sure,
as you talk? Thank you.
no problem.
And Dr. Barreto, if I heard you correctly, your specialty area is in ankle and foot issues.
Yes, exactly.
Okay, and tell me, for example, the case we're talking about today is going to involve multiple fractures of the foot. How many times in a typical week do you see cases like that?
Well, I see cases with fractures of the foot and ankle all the time. Patients who've been run over with multiple foot fractures is not terribly common because I don't work at a level 1 trauma center, but I certainly have comfort taking care of those types of injuries as well.
Okay. Can you tell me, please, what would, well, let me ask you this also. Have you published any journals or any academic papers or anything of that nature that we would need to know about?
Well, I'm the orthopedic division director here at Emory. I used to be the head of our fellowship, but one of my partners took over. The last time I checked, I had around 75 peer-reviewed publications, and I don't know how many presentations at this point. But yeah, I have a bunch of publications.
Okay. Can you tell me, do you, as you sit here today, do you recall getting a chance to meet with Ronald Shackleford?
Vaguely, I would tell you that if you put him in a room, I don't know that I'd be able to pick him out of a crowd, that kind of way, but I sort of vaguely remember his case when I reviewed his notes today from my office this morning when I got to the office.
Okay. Dr. Berto, I'm going to try to do a screen share here so we can be kind of looking at the same thing.
Sure.
Let me see if I can get this to work.
I have his notes printed too, if you tell me what date.
Okay. That may work. Megan, does that work on your end?
Yeah, that's fine with me. I have them printed too.
Okay. Dr. Berto, I'll direct you to, as I'm reading through these, if I'm reading it correctly, I think they're in kind of reverse chronological order. Is that right?
Yeah, so I have the first visit on September 9th, I think 2019. Yeah.
All right. And as you look at your notes, what was Mr. Shackleford coming to you for?
I think he was
that day on
seeing
September 9th?
me for a second opinion, as he described having his foot run over by a truck, and had multiple injuries to his midfoot.
Okay. And at that time, did you have imaging that you could look at and see what was
Yeah.
going on inside his foot?
Yeah, so we had x-rays and I believe a CAT scan, and so his x-rays had widening of his midfoot called his Liz Frank joint. His Liz Frank joint, I wish I brought a bone model. I'm sorry, I could get one if that's okay, but if it helps at all. But it's basically his midfoot joints, sort of in the middle part of his foot, had fractures and dislocations, which are better described on his CAT scan.
Okay. Dr. Berto, if you have one of those models there, I think that would be helpful. If
All right,
you
let
could
me
take just
grab it.
maybe
Give me
a
2
2-minute break.
Give me
Video
2 minutes.
record at 3:42 p.m.
Give me 2 minutes.
Back on the video record at 3:43 p.m.
Okay. Dr. Berto, you were demonstrating where the
Yeah, so if you look, this is a right foot. He had injuries across his Liz Frank joint, which is the tarsometatarsal joints. So these longer bones here are your metatarsals, and where it articulates with the midfoot is called the Liz Frank joint, named after a French anatomic surgeon from a long time ago. But basically, he had fractures and instability all across this joint. He also had some instability and fracture of his cuboid as well. And I have his pictures of his injury films as well, if you want me to show those.
yes, sure. If you think that would be helpful.
Well, I think you can just see that there's an abnormal widening here that's not normally there. You can see fractures here. And then normally you can see joints here, but there's fractures at all of these base joints and sort of significant involvement of this whole area across his midfoot.
Okay.
And that's where his injury occurred.
And Dr. Berto, you said Mr. Shackleford represented to you that this was from a truck running over his foot.
I just have to look at my notes to confirm. I wrote in my notes a 45-year-old male who had his left foot run over by a truck 1 month prior to the presentation to me.
Okay. And the injuries that you observed on the film and also in person, were those consistent with that type of
Yes.
cause?
Yes.
Okay. In addition to looking at the films, did you have a chance to look at his foot close up and manipulate it and see how it was looking?
Yeah, we examined his foot. There was significant swelling, but he also had changes with peripheral vascular disease. He had significant moderate tenderness to palpation. His pulses weren't great. He didn't have any ankle instability, but he had a pain throughout his foot.
Okay. And here under the CT scan, when it says is it comminuted?
Yeah,
Am I pronouncing
comminuted
that right?
just means the bones are fractured in more than 2 pieces. So, they describe his comminuted fracture of the base of the second metatarsal is here. Comminuted transverse fracture of the medial cuneiform is this bone here. I don't know if you guys can see where I'm pointing. Mild depression of the proximal articular surface means that there's normal joint surface and then it's impacted if it's depressed. They noted that he had subluxation, which means the joints aren't normally aligned. He had a comminuted fracture of the middle and lateral cuneiforms as well. And then he also had a comminuted fracture of the cuboid, which is this bone over here on the outside, and small fractures of his calcaneus anterior process and his sustentaculum, which is parts of the calcaneus here. Here.
Okay. And Dr. Berto, was it your understanding Mr. Shackleford had gone to the emergency room to have his injuries assessed the day of the accident?
I need to
You can go ahead and answer. That just means she objected to the way I asked the question.
Okay. I can only tell you what my notes say, and it says that he was seen by a foot and ankle specialist on his initial evaluation as well as a subsequent ER visit. I assume he was seen in the ER originally on the first day because I wrote he was admitted to the hospital, but I don't have that specifically that he was seen in the ER or had those notes at that time.
Okay, okay. And he was seeing you for the first time about a month after that, after the injury, correct?
Yep, that's what I wrote.
Okay, okay. And here where it talks about anterior process and
Sustentaculum. Yeah, those are small pieces of the calcaneus. The anterior process is this sort of area right here. If you look on the bottom aspect of the calcaneus, there's this piece right here called the sustentaculum.
Okay, there were fractures there as well?
Yeah, they're both parts of his heel bone that were fractured on his CAT scan.
Okay, okay. And what was your so have we fairly gone through kind of what your diagnosis was, what the issues were that he came in with?
Yeah, I mean he's a 45 I think at the time, gentleman who had a complex fractures of his midfoot with instability of the joints.
So with all that in mind, what did Mr. Shackleford elect to do?
He elected to treat it conservatively. We placed him in a boot. We maintained him non-weight bearing. We needed to monitor him closely, and we elected to see him back a month later with no more x-rays.
Okay. And okay, Dr. Berto, anything else from that first visit that we need to be aware of?
No, I think we covered it pretty soundly.
Okay. All right, let's move on to the visit on, that was about a month later. I've got October 21st.
Excuse me, I just wanted to ask Dr. Berto if he would just slow down just a little bit.
Yes, I'll try to do that. My apologies. I'm from upstate New York. I have always been talking too fast. Sorry.
I understand.
So
No
I
problem.
think that I have a canceled visit on the 21st, on October 14th. And then do we have when is the next visit we saw him? I have an October 21st visit. I think it's the second visit I saw him.
All right, so Dr. Berto, you saw him about a month later. Did you notice any changes in his foot versus the first time?
I noticed that he's had some, I commented more here that I thought he had more elements of neuropathy. I wrote that he had mildly diminished sensation of light touch. I'm trying to look at my notes. That would be the exam findings.
And Dr. Berto, the neuropathy you described, is that, I just want to make sure we're clear, is that more of a chronic condition that he had, that you think he had before the injury, or is some of this because of the injury?
I think it's probably more likely related that it's sort of chronic in nature. When there is what we describe as a crush injury to a foot, there can be some nerve issues that can occur. But, I thought he probably had some element of neuropathy at baseline.
Okay. And I believe at that time, was he still, now the first visit, he was in a boot, correct?
I'd have to go look. I don't remember. I think we put him in a boot at the end of that visit, but he came in a splint.
Okay.
Yes.
And I'll refer you over to the third page of that October 21st record, about 3 lines down. It says he will continue.
Yeah, he will continue to wear a boot and can progress to weight bearing. Because he's actually 6 weeks at that point. So he came and saw me on the 9th, and this is on the 21st of the following month. So that's about 6 weeks later. So he's 10 weeks from his injury. So at 10 weeks, typically it's reasonable to start placing him in a boot.
Okay. And now at that visit, did you guys kind of discuss again, any possibility of surgery, or was it just already agreed that it would be a more conservative treatment?
Well, the challenge was he had seen someone else for a second opinion. They ordered an MRI because they thought he had an infection. I never thought he had an infection. I thought that it was likely what we would describe as swelling related to his injury or dependent rhubar. He didn't have the MRI with him. I didn't see any signs of infection on his exam, and so I recommended continued conservative treatment at that point and didn't elect to proceed with I didn't think, he hadn't done anything we asked him, right? He hadn't stopped smoking, those types of things. And so, without making any progress in that regard, I didn't think surgery was a good next step.
Right. And Dr. Berto, I think I saw you mentioned somewhere in your notes that he had been a smoker going back a number of years, correct?
15 years prior is in my notes from the first visit.
Okay. I just want to make sure you're, obviously he didn't suddenly pick up smoking after this accident. That was just something he already had going on, correct?
As far as I know from my notes.
Okay. And Dr. Berto, in your experience, do patients who have been smoking for a time, do they sometimes have difficulty, weaning themselves off of smoking?
Sure.
Okay. All right. And as you left that second visit, what was kind of the long-term prognosis looking like for Mr. Shackleford?
Well, I don't know that we commented specifically on his long-term prognosis in the notes, but the plan was to continue treatment, and since he was not proceeding with surgery, I had referred him to follow up with his orthopedist back home.
Okay.
Or at least commented that he didn't have to come all the way to Atlanta, because if I recall, he's not from Atlanta. He came and see me from a distance away, but if he wasn't proceeding with surgery, I didn't think that he had to follow up in Atlanta.
Okay. And then, Dr. Berto, I think the final record we have, his final visit, was actually a telehealth visit on April 29th, 2020.
Yeah, that's probably mid-COVID, I think, right? Right in the beginning, maybe?
Right.
Yeah.
And so obviously with it being a telehealth visit, you didn't have an opportunity to examine him there in person, but as you recall from your notes, what was conveyed to him during that visit?
Well, we did examine him. We put together a protocol where the patient could stand in front of the video screen and point to where it's not a true exam where you can touch him, but we put together a protocol to give some element of alignment issues. I discussed with him that if he couldn't do that, he needed to do shoe wear modification, inserts in his shoes, consider bracing. And then I also thought pain management with his primary care provider would not be unreasonable if he developed chronic pain that he couldn't manage with the things I recommended.
Okay. And he did report there on that second page of that record, says he does report chronic pain in his foot.
Yeah, he reports chronic pain in his foot that he's treating with his primary care doctor using Xanax and gabapentin.
Okay. And you said, just based on the video, you were able to see that he still had some moderate swelling at that time?
Yeah, so we wrote in the video that he had a neutral ankle with a reasonable hindfoot alignment. He described focal pain throughout his midfoot. We noted he had moderate swelling. He had decreased ability to bend his toes, but there was no wound breakdown or calluses that we could notice on the video.
Okay. And at this point, we are you're about 8 months after the original injury, correct?
Right. So it's probably early August. So August, September, October, November, December, January. Yeah, 8 months. Okay.
Is that typical to still be seeing significant swelling and?
Yes. So what I tell all patients who have surgery on their foot or fracture their foot, it's a year before the swelling and everything is at its best. So at 8 months, I would expect the patient to still have swelling and still have some issues recovering.
Okay. Okay. Well, Dr. Berto, with the conditions that you saw Mr. Shackleford presenting with, what types of things, if you can just kind of give us a snapshot of what things would you expect him to be able to still do, and where would he have some limitations? So for instance, would you expect him to be able to walk for any considerable period of time?
I think he should be able to walk. I think the challenge would be if he's developing significant arthritis and pain, he may be limited. I certainly think impact exercise like running, jumping, or cutting sports would be challenging. I think things like swimming in a swimming pool, possibly an exercise bike, some patients can do very well with, and manage. But certainly if he's having chronic pain and swelling, it's not surprising that anything involving his foot with prolonged standing or walking would cause pain.
Okay. All right, and I think you mentioned something about he should, I think even in the note here, it talks about transitioning from the walking boot to some other form of footwear.
Yeah, I mean, I think, at that point, we want to try to get him into regular sort of shoe wear with an insert. That's more of an arch support with cushion. A walking boot, 8 months after this injury is not going to provide any significant benefit other than limit his ankle range of motion. It's not protecting him at that point. Those fractures are healed and the arthritis is what it is. So things like an insert in his shoes or a rocker bottom sneaker to reduce the stress across his midfoot would all be things we would consider.
Was there anything else significant on that September 2021 visit?
No, we had discussed with him getting a referral to an outside podiatrist to get injections maybe to treat some of his arthritis. He had a reasonable sensory exam, which meant, he was progressing well in that regard. But he definitely, was still having some pain and swelling across his midfoot.
Dr. Berto, is there anything else concerning kind of his long-term prognosis that we need to know about that you haven't already told us about today?
I don't think so.
All right. Thank you for your time. Please answer any questions that Ms. Peeler may have for you.
Sure, happy to do it.
Sure. Can we go off the record just for 1 minute?
Off the video record at 4:11 p.m. Back on the video record at 4:16 p.m.
Okay. Good afternoon, Dr. Berto. My name is Megan Peeler. I represent the defendants in this case. Thank you for giving us your deposition today and agreeing to answer our questions.
Sure, no problem.
So I want to start with kind of the beginning of your treatment of Mr. Shackleford. And you have in your notes that it was a 45-year-old male who had his left foot run over by a truck about a month ago from your September 2019 note. Is that correct?
Yep.
And you agree that the only thing that you know about this accident is what Mr. Shackleford told you. Is that correct?
100%.
You have no personal knowledge of the accident that was at issue, correct?
Correct.
Did you see any photographs of the truck that was involved in this accident?
Nope.
Did you see any photographs of the scene of this accident?
Nope.
Do you have any idea how fast this truck was traveling when it impacted Mr. Shackleford's foot?
I do not.
Do you have any idea what Mr. Shackleford was doing when he was involved in this incident?
I do not.
Do you have any idea what part of the truck made contact with Mr. Shackleford's left foot?
I don't.
Have you treated patients with injuries sustained in pedestrian motor vehicle accidents before, such as in your residency or before you were at Emory?
I have both. Yeah, in my residency as a fellow and then as an attending. I practiced at Grady for my first 2 years as well as at Emory, so I did see some pedestrian struck as well.
Okay, so when you were practicing at Grady, what sorts of injuries did you see when you were treating pedestrians that had been struck by motor vehicles?
I mean, all the orthopedic problems when I took call, ankle fractures, femur fractures, even upper extremity injuries.
Would you treat patients that had multiple different injuries to multiple different parts of their bodies when you were at Grady?
I did occasionally. I didn't take much call there, so I usually got referred patients to take care of their foot and ankle problems. I was still doing foot and ankle there, but occasionally on call, I would have to do somebody with a polytrauma or a multiple extremity involvement. Definitely as a fellow, though. Sorry about that.
Okay. Can you describe what would be an example of kind of a trauma with a multi-extremity involvement?
Oh, like somebody who has a femur fracture on their left leg, an ankle fracture on their right side, and then a humerus fracture on their right arm. I mean, multiple extremities involved.
And those would be sorts of injuries that you observed in your residency or in your fellowship from some sort of motor vehicle accident, correct?
Yeah, I mean, I'm not saying those are limited to just those type of injuries, but the really bad pedestrian struck, they could have something very severe like that.
And you agree that the only injury that you treated Mr. Shackleford for was his fractures and broken bones in his left midfoot, correct?
Correct.
When you treated Mr. Shackleford, did he ever have any bones protruding from his foot?
When you say protruding, like prominences and that kind of stuff, like sticking
Right,
out,
outside
like,
of the skin.
no, he did not have comminuted or he did not have any open fractures, or the common term is compound fractures. He did not have any of those type of injuries.
Okay. And a compound or open fracture, is that where you can see kind of to a lay person that the bone is outside of the skin?
Exactly.
And Mr. Shackleford did not have any sorts of fractures like that, correct?
Correct. On his foot that I took care of.
Okay. Did you see any injuries to his leg on that foot that you took care of, or was your treatment solely confined to the left foot?
I don't have any comment in my notes, and I'm pretty specialized when patients come in and see me, so I don't recall anything else going on, and I didn't comment it in my notes.
Okay. Dr. Berto, every patient-physician relationship, I would say, kind of involves two components. The doctor has the training and experience to treat the patient, but do you agree that it's fair to say that the patient also has some responsibilities as well?
Sure.
So let's go over some of the patient's responsibilities. Do you agree that the patient has the responsibility to follow, as far as practical, the doctor's orders and recommendations?
I think that's always helpful to patient care for sure.
And that would include following doctor's orders and recommendations about post-injury care, correct?
Sure.
Or follow-up treatment that the doctor recommends?
Sure.
And would you agree that that's because to have the best possible outcome of treatment, a patient needs to, as best as practical, follow what his doctor recommends, right?
Sure.
If a patient does not follow his doctor's recommendations, that can affect his ability to ultimately get better, right?
100%.
And if a patient is not compliant with his doctor recommendations, that can mean that his injuries are not going to heal properly, correct?
Sure.
And I want to kind of talk more specifically now about Mr. Shackleford's treatment. And your first day of treating him was September 9th, 2019, is that right?
Yes, that's what the notes say.
And based on your notes, that was about 1 month after this incident, correct?
Yep.
Do you know who referred him to you for treatment?
No.
I saw in your note that it said they did not contact me prior to referral. Do you know, what does that mean?
So if you have a complex problem in the community, like an injury you're not comfortable taking care of, it's usually common if you're going to send someone to a super specialist like I am, to give them a call ahead of time to say, hey, I have this patient with this really bad injury I'm not comfortable with. Can you help us out? Because that's the type of thing where I would say yes, and then my staff would get that patient in immediately so that we don't have delays in care. And what I was just commenting here is that no one did that, and so he's much further out than would be ideal for me to see him for a first visit.
And what do you mean by he's much further out than would be ideal for a first visit? Kind of explain that for us.
With an injury like this, I would want to see the patient within the first 7 to 10 days of their injury, see how their swelling is, because if I needed to fix it, I'd like to get it done before 2 weeks, 3 weeks at the absolute most, because once you start to get further out, you have to start thinking about doing different procedures because the either healing of the bones has occurred already, there's scarring that has occurred. And so seeing a patient with this type of injury a month out makes it much more challenging for me to take care of him.
And there's a better potential outcome if you can see a patient more quickly after a broken bone kind of injury like this, right?
Well, the thought for this specific injury is that I may have been able to think about doing what's called an open reduction internal fixation instead of a fusion. So I would be able to just realign the bones and fix them as opposed to trying to fuse them. Now, I'm not 100% sure I would have been able to do that at 7 to 10 days out based on swelling and or, his injuries had comminuted fractures, and so I may not have been able to do that. But certainly a month out, it definitely limited my ability to even consider that as an option.
And when you saw Mr. Shackleford a month out, you also have in your medical notes that he's a current everyday smoker, approximately 1 pack per day. Is that right?
Yep.
And that was based on your treatment and the history that Mr. Shackleford gave you. Is that right?
It was, yep.
Can you explain to the jury what is peripheral vascular disease?
So peripheral vascular disease is narrowing of either the arteries of the veins in the legs, or it can occur in the arms, but most commonly in the legs and the feet, which can occur over time due to any number of reasons, but it reduces the blood flow in or the body's ability to get fluid out of the leg. And when those things are going on, it increases complications related to foot and ankle surgery.
And to a lay person, vascular disease is not something that's caused by an injury such as this, right?
No, that's a chronic problem that was present prior to his injury.
Okay. And does significant 15-year smoking history, does that contribute to a potential for vascular disease?
100%.
And why is that?
Oh, you're making me think about medical school now, but there's pathways where the smoking itself can cause vasoconstriction and chronic changes. Plus the nicotine itself is a vasoconstrictor. But I'd have to go back and to give you the specific pathways that lead directly to peripheral vascular disease. It's been a while.
And what was the non-surgical treatment that you recommended that he follow at this point in September of 2019?
It's to begin to go into a boot instead of being in a splint, and to be non-weight bearing or not put any weight on it.
What's the difference between being in a boot and being in a splint?
The splint is like part of it. It's like a half a cast with an ACE wrap around it. It's just a plaster level or some type of hard material that has padding and then holds the foot. A boot is like off the shelf boot that protects the ankle and the foot while a fracture and or injury to the foot or ankle is healing.
And does a boot provide greater support than the splint that he was in provide?
I don't think one provides greater support than the other. They're more convenience than anything else. I like splints after surgery specifically because, or after like a fracture, because they can get right up against the bone really well and be molded, as well as they can protect incisions and that type of thing. A boot is nice though because it can be taken off, you can change your socks, you can bathe, those types of things.
And your next visit with Mr. Shackleford was about a month later in October 21st of 2019, is that right?
Yep.
Okay. And I'm looking at one of the notes made by your office, and it looks like you wrote, he was instructed to be non-weight bearing in the boot, but he has not been compliant with that. He has also been smoking daily despite our advice to stop smoking. Do you see this?
Yeah, I'm just trying to find it. Is it on page 2? Yes, I see it. Yep.
Okay. So based on this note, in October of 2019, Mr. Shackleford was being non-compliant with your recommendation and instruction to be non-weight bearing, correct?
Yep.
Why is it important that a patient with this sort of foot injury be non-weight bearing during this time period of the injury?
And we want to try to get the fractures and the bones to heal as quickly as possible. And certainly weight bearing may contribute to increased swelling and pain as well as possible displacement of the injury.
So essentially putting weight on the foot too soon can interrupt the healing process, right?
Well, it certainly doesn't make it optimal.
And can it also cause further damage to the ligaments or other structures in the foot if the patient's putting weight on that foot during this time period?
It's possible. Certainly possible.
And how could you tell that Mr. Shackleford was non-compliant with your instruction to be non-weight bearing?
He probably walked into my office with the boot on. That's the only way we would tell. If he came in with crutches and didn't put weight on it directly in front of us, we wouldn't have put that in our note.
Okay. So based on your note, you could see based on some sort of personal knowledge or personal observation that Mr. Shackleford was not compliant with being non-weight
He
bearing.
either told us he was non-compliant or we saw him in the office be non-compliant, either me or my assistants.
Okay. And your second instruction to Mr. Shackleford was to stop smoking, right?
Yep.
And can you explain kind of briefly to the jury why it was important for a patient such as Mr. Shackleford to stop smoking?
Well, it's always helpful anytime a patient is a smoker. If they stop smoking, improves blood flow to the foot, which can always sort of try to speed up the healing process. So I always advise patients to stop smoking during a recovery from an injury or recovery from surgery, or before surgery I have them stop just to try to make sure they have the best chance possible to heal.
And based on your note from October 2019, Mr. Shackleford did not follow at least 2 of your instructions, right?
Well, he didn't stop smoking and we saw him weight bearing. or somehow knew he was weight bearing. I don't have specifics. I just know that we said he was non-compliant in the note.
And your next visit with Mr. Shackleford is April of 2020, is that right?
Yep.
Do you know why he waited 6 months to come back for a follow-up with your office?
I don't. What did we say to him? Yeah, I mean, I think that we had at that October 21st visit had elected to proceed to treat him conservatively without surgery. And so in that note, I advised him that he could follow up in Athens, I think is where he's from. And so when he came back and saw me later, that's not, I mean, that's just him coming back in, but I wasn't expecting him to follow up again. I was expecting him to follow up in Athens unless he was thinking there was something else going on or needing surgery.
Okay, so he followed up with your office in this April of 2020, and I'm looking at your note that goes from page 2 to 4.
Yep.
And since you have not seen Mr. Shackleford since April of 21, do you have any personal knowledge of whether or not he stopped smoking?
I have no personal knowledge since September of 21 about Mr. Shackleford.
Okay, and as of September of 21, when he saw you, he was still smoking, correct?
Yep.
And since you haven't seen him since April of 21, you have no personal knowledge of what his current condition is today, correct?
Of September of 21, but yes, I don't have any idea how he's doing today.
Okay. You have no knowledge of how he can ambulate currently today?
I don't, nope.
Since you haven't treated him since September of 21, do you have any opinion or knowledge as to what his long-term prognosis is?
Well, I certainly think that just based on his injury, I know that he's going to have significant issues with his midfoot, because just any patient who had his injury is always going to have a challenge with their midfoot, with pain, difficulties, with prolonged standing, walking, those types of things. But do I know how he's doing exactly today? Currently, I do not. But I certainly think long-term his midfoot's always going to be a challenge. I think it's because of his original injury. His injury itself, even with perfect surgery at the time or the fusion procedure later, would definitely still contribute to someone having chronic limitations in their foot. Even with the best surgery, with the injury he had, it's definitely a challenge long-term to be able to, do super impact stuff. A Liz Frank injury is a very challenging injury to deal with when it involves multiple joints all the way across the midfoot. There's even small fractures of the cuboid and the calcaneus. It was a big injury.
And when you say he has significant limitations as to high impact activities, what sorts of activities are those? Or would that be running, jumping?
Yeah, running, jumping sports are always very difficult for these types of patients, but even prolonged standing or long walks can be challenging. They almost always need soft cushioning insoles with good support. Often patients do better with a stiff shoe, like a Hoka brand is a common brand to think of, that have a rocker bottom sole built in. Those are things those type of patients who have these big midfoot injuries tend to need to be able to deal with.
Would you recommend that a patient who had this sort of Liz Frank injury in 2019 still wear a walking boot today?
Not usually, no.
Okay. So when you say supportive footwear, are you saying like off the rack sneakers that have a good supportive base?
Yeah, off the rack sneakers with a good supportive base, and then probably with chronic, for Liz Frank injuries, typically at this point I would have someone in a custom orthotic or at least a good over-the-counter orthotic, which is an insert that goes in the sneaker or shoe. And we had recommended recommended over-the-counter orthotics, and we gave him a script on his last visit for those.
Okay, and do you know whether or not Mr. Shackleford was compliant with getting over-the-counter orthotics?
I do not know.
Hi, Dr. Merito. I just have a few follow-ups. Earlier, Ms. Peeler was asking you about the fact that you saw Mr. Shackleford for the first time about a month after his accident, right?
Yep.
And she talked to you about the delay from him being seen at the ER to being seen by you, correct? And you talked about that ideally it would have been good for you to see him 7 to 10 days after his initial accident, right?
It would have been helpful to be able to, if we had thought something surgical would have been, we at least could have had the discussion about fixing his foot as opposed to fusing it.
Okay. Do you know, Dr. Berto, do you know anything about the facts and circumstances that led Mr. Shackleford for it to take a month for him to be seen by you after his accident?
I can only tell you what's in my notes,
Okay.
which basically, he was seen in the ER, I think at least once. He couldn't get into an outside office, and I couldn't figure out why. It doesn't really say in my notes. It just says it's unclear why he couldn't get in.
Okay. So whether that was something on the facilities side or Mr. Shackleford's side, you wouldn't have any way of knowing,
I
right?
have no idea.
Okay. Ms. Peeler talked to you about the October 2019 note where you stated that Mr. Shackleford had been non-compliant on the weight-bearing aspect.
Yep.
Now, and I know you pointed out that he had not been compliant on the weight-bearing, but at the same time, in that same note, you also say, well, look, going forward, it's okay for you to be weight-bearing on that foot, correct?
Yeah, at the end of the visit, we had instructed him to be weight-bearing and starting at that visit.
Okay. Was there any specific injury or bad thing that you saw that happened as a result of this non-compliance with the weight bearing on his foot?
I didn't comment that there was any specific change based on his imaging or x-rays that we got that day. I'd have to put both of them up side by side to see any difference, but there was certainly nothing that grossly stood out to me in my note that day.
In other words, he didn't refracture anything or dislocate anything new as a result of the weight bearing, as far as you could tell.
As far as I could tell, but I don't know.
Okay. Let me look with you at the September 2021 report, and that was the last time you saw Mr. Shackleford in the office, right?
Correct.
Okay. At that time, he stated he was still having pain in his left foot, correct?
Yep.
He said it was in his midfoot area, which is what you would expect, right?
Correct.
He was rating that pain at a 9 out of 10 at the worst.
Yep.
Do you see that?
Yep.
Okay. He said sometimes that pain kept him from sleeping. Do you see that?
Yep.
Okay. And you state that in your notes there, you state that he is able to limp around. Do you see that?
Uh-huh.
Okay. So over 2 years after this accident, Mr. Shackleford's still reporting pain at a 9 out of 10, pain that's not able to let him sleep, and he's still limping around, correct?
That's what he stated in my office.
Okay. All right, and that was that consistent? Was that representation consistent with what you saw in terms of just kind of your objective observations of him when he came to you in your office in September of 2021?
I'm not clear with the question. Can you help me with that?
Sure. Mr. Shackleford was reporting pain at a 9 out of 10, and I think you state here that he's able to limp around. I guess what I'm asking is that something he reported to you, or is that also something that you observed when you saw him there in the office?
The limping around he reported to me, and you reported that he had 9 out of 10 pain. I didn't comment whether he specifically limped in my physical exam, so I can't say.
Okay. All right, and nothing in your physical exam caused you to question either of those things that he reported to you, correct?
I mean, he said he had pain when I examined him and pushed on the areas that would be typical for somebody with his injury.
Okay. And since at that time he was 2 years out from the injury, does that give you any indication? I mean, he's undergoing this conservative treatment. Is he anticipated to get better, or is it something where a year from now he'll still be at a pain level of 9 out of 10? Or
describing a level of pain is very challenging for me for patients. I would say if a patient is still having pain 2 years after a big injury like this, do I think they'll continue to have pain I do think they'll probably continue to hurt.
And likewise with, 2 years out from the injury, he is still showing some sort of limp. Would you expect that to be kind of the long-term prognosis, assuming there's no surgical intervention or something doesn't change?
He reported to me that he was limping, but I can't say, I didn't describe a limp, so it's difficult for me to say. I don't have that in my physical exam, so I don't know, whether he had just an antalgic gait, whether he had a bad limp. I just can't comment. I don't remember.
And Dr. Berto, at that time, at that visit, I see here under gait ambulation, you report that he had a walking boot on at that time?
Yes.
Okay, is that would that also, what did that tell you, that he had a walking boot on still?
I'm not sure. I would be surprised, even with a bad injury, for someone to still be in a boot 2 years later. I would say, I don't know what, that doesn't really tell me anything.
Okay. Okay. And here on your examination for that date, it also says moderate swelling of the midfoot. I know earlier you were talking about that when you have a severe injury like this, you can usually expect it'll take a year for the swelling to go down, but at least in this instance, it looks like he still has moderate swelling 2 years after the accident.
Yeah, I mean, he's got arthritis now, and so arthritis is probably leading to continued swelling in his midfoot, as well as the alignment of the bones not being ideal.
Okay. All right. Dr. Berto, I think that's all I have. Thank you again for your time.
Sure.
Dr. Berto, I think I have one more follow-up question. Sorry.
Go ahead, no problem.
Okay. I'm looking at your September 21 note, and you've described that Mr. Shackleford will have chronic pain, and this was sort of a big injury. But in your note as of September 21, you stated overall he has no limitations and can do whatever he feels comfortable doing. Is that correct?
Yeah, so basically if, he wants to walk and can tolerate it, he can do it. If he wants to try to do things, he can tolerate it. The only thing that I think would limit him is what his foot will allow him to do.
And like we talked about, you would expect that those limitations would be high impact type activities such as running or jumping or
running,
heavy
jumping,
workout.
prolonged standing, those types of things, working a desk job I don't think would be a big issue, but standing all day and doing that type of stuff would be challenging.
Okay. I don't have any further questions.
Excellent. Okay. Sorry, George, no questions. Mr. Ramsey, next witness.
Your Honor, our next would just be the exhibit we discussed before, that table. I've shared digitally a copy of it with opposing counsel. I don't know if
we can talk about that. I know you want to get that in. There's possible judicial notice to be taken of something. We can work through that while the jurors are on a break. So assuming that you have teed that up for discussion and not waive the ability to get either this table in, if it's coming in, or have judicial notice taken of that fact. Anything else?
no more witnesses, Your Honor. It'll just be those issues you just mentioned.
Okay, so this time this plaintiff rest.
We do, aside from the issues you referenced, Your Honor.
Okay, excellent. Then, ladies and gentlemen, we are at a natural break point, not in the sense of break and go home, but break because I need to talk with the lawyers about a few things. So you're going to get a second afternoon break, not driven by any technology things. While we hash out a few things, we'll get you back in here as soon as we can. The fact that plaintiff has rested doesn't mean you start your deliberations. There is still a whole side of the case that we may get if the defense wants to put on any evidence. So please, no outside research, don't talk about the case, and we'll see you soon.
All right,
Right, you all can be seated. Let's cover a few things and then if we need a break, we'll certainly get you a break. I'm going to start with the mortality table. Ms. Peeler, I've reviewed some statutory law as well as case law. The mortality table that Mr. Ramsey has belatedly shared with us and we'll need to get a hard copy of is in fact a part of the evidence code. It is an appendix to OCGA 24-1445. It's an alternate mortality table. The one that the code seems to favor is in 24-1444, called something like the American Experience Mortality Table. But I don't think there's a reason to say you have to use one versus the other. I've also found some cases that say when there is evidence in a case that a plaintiff may continue to experience damages as a result of the alleged negligence of the defendant, it's appropriate for mortality tables to be introduced so the jury isn't purely guessing, well, how long might this guy live? So I think it's appropriate. I don't think there needs to be an actuary who comes in to say this is in fact the mortality table. I think our legislature's already done that for us. But I want to give you a chance to say those cases are wrong, the statute's wrong.
Your Honor, I had a chance to review the mortality table that he sent. He's in the code section. I don't have any objection to it coming in. If he puts it into evidence, I'm not sure that just emailing us the code section has it in evidence. That would be our only exception.
Sure. So before we close all the evidence, Mr. Ramsey's going to need to figure out how he's going to get a hard copy that doesn't say Justitia, out of date, formerly 2019, whatever, but is that appendix. And if it matches with what you understand the appendix to be, I think it is admissible as it is because it is part of our OCGA. Because at play is this question of ongoing pain and suffering. It's not admissible in carjacking case or something like that. But here, based on the cases I looked at, Bibbs versus Toyota Motor, and a real old one, Cox versus Cantrell, I think it has a place in this case. So if you get us a hard copy that is in fact that appendix to OCGA 24-1445, we'll let Ms. Peeler take a look at it. As long as it conforms, I am admitting it and it will go back to the jury.
And your Honor's concerns were that it says Justia at the top and then not the most recent version or whatever it was it said at the top.
I'm not the one who is going to object to it, but you're going to need to make sure that whatever you print out, if you come in without the ability to print more things, is something that works for Ms. Peeler. So you may want to email to her first. I intend to print this out verbatim, word for word, because once you do that, that's what you're working with. And if there's a valid objection to it, it's not going back.
Okay.
Okay.
And your Honor is, I'm fine with not putting it up at this time, as long as I can put it up later. I just want to make sure I'm not closing the door on my opportunity to put it up later by not. And I'm not even sure what I would do. I don't want to really be a witness saying, here's what the table says. It would be more in the argument.
You would say, Judge, at this time, the plaintiff is tendering plaintiff's F, whatever letter we're on. It's the. I went away from it because I was interested in another case that related to all this stuff, but whatever it's called, the mortality table of 1949. Any objection? No objection, because we've already worked through it, assuming it's what you say it is, and then it's in.
Okay.
I wouldn't expect you to put it up and talk about it.
Okay. And we can do that after we've rested and there's no issue there. Okay.
But Ms. Peeler can also object to it after you've rested.
Sure.
And if there is a valid issue with what it is you're trying to get in, it's not coming in.
Okay, fair enough. Thank you.
But an objection, I don't like mortality tables, or there's no foundation or anything like that, that'll be overruled.
Okay, thank you.
But if you've circled it saying pick this one, that would be an objection.
Right, I'm not going to mark it up.
In terms of judicial notice, which is the other piece of your presentation, I don't have an issue with the language that you've proposed. I've already told defense that I think it is appropriate under the law to take judicial notice of things like the phase of the moon, sunrise, sunset. Those are all scientifically verifiable facts. And I think the format, like something along these lines, is more appropriate than admitting the piece of paper from moonpage.com. Ms. Peeler, did you have any concerns about the language within the quotation marks in the request to take judicial notice? If you haven't had a chance to look at it, there's not a rush on this one. I will be telling the jury at some point before both sides rest.
Yeah, Your Honor, we don't have an objection to the judicial notice of the moon. I think there's maybe some language in this that we would object to.
Okay.
But as far as a standard pattern charge on judicial notice of the moon phase, we don't object to that.
Okay, good. So the pattern charge is going in, but of course, the meat and potatoes of what I'm taking judicial notice of will need to iron out, because at some point before the charge, I'll also say I'm taking judicial notice of this, and then I'll remind them in the charge, there was this judicial notice taken, and you must accept that as fact. So wordsmith it with Mr. Ramsey, and we'll figure out what it is I read to the jury.
Okay, thank you, Judge.
All right, Mr. Ramsey, anything else?
No, Your Honor.
Okay. Ms. Peeler, the plaintiff has rested. Anything from the defense?
Yes, Your Honor. At this time, the defendants are moving for a directed verdict on all of plaintiff's claims asserted against Georgia Power. Your Honor, under OCGA 91150A, a directed verdict is appropriate if there is no conflict in the evidence as to any material issue, and the evidence introduced, construed most favorably to the party opposing the motion, demands a particular verdict, and we think that is the case here. Mr. Shackleford has introduced no evidence that Georgia Power was negligent. Shackleford testified on direct exam that he was walking with his left foot a little bit over the white line on the road. Shackleford told the jury that as cars would pass him, he would get out of their way by moving over on the road. And importantly, Your Honor, when it came to Shackleford describing the instance at issue that led up to this incident, he said that he felt the lights from Eric's bucket truck approaching him. He got over to the white line, which is saying that he was in the road, made his way over to the right line, turned around, saw the bucket truck coming at him, and dove out of the road. That was Mr. Shackleford's testimony on his direct examination. And Your Honor, we addressed this a little bit at summary judgment, but there the evidence was different. There at summary judgment, the evidence was Mr. Shackleford outside of the fog line? And if so, does that mean that Eric's bucket truck had to have crossed the fog line to strike him? Given the evidence and how it has come in at trial, that is not an issue anymore. The only evidence of Eric Morris's driving is that he was driving at or under the speed limit. He was paying attention, maintaining a lookout, and took an evasive maneuver to avoid Mr. Shackleford. Mr. Shackleford did not testify that Eric Morris crossed the white line. Instead, he said he was in the road, he turned around, he dove out of the way. And we would tell the court that under Georgia law, judgment is appropriate as a matter of law to Georgia Power because there is no evidence other than speculation and conjecture that the jury could find that Georgia Power was negligent. And Your Honor, I'd point the court to Hunsucker versus Belford for the record, 304 Georgia App 200, 2010 Court of Appeals case. Also a federal court decision from the Northern District, Little versus New Prime Inc. And that's a 2021 case. And Your Honor, especially in the Little case, there's a statement that I think is very applicable to what's at issue here, where the court granted judgment as a matter of law, where a jury could only speculate as to whether the driver should have done more to evade a collision, and guesses or speculation, which raise merely a conjecture or possibility, are not sufficient to create even an inference of fact for consideration. Here, the only evidence that plaintiff, I think, may try to argue in response is, well, Eric maybe could have been keeping a better lookout. Maybe he should have perceived Mr. Shackleford in the road. But asking the jury to find that is asking the jury to speculate and conjecture whether he could have evaded the collision differently. And that's not the law in Georgia. The law is that if evidence is based on speculation and conjecture, that does not go to the jury. That is a finding of directed verdict as a matter of law for Georgia Power.
All right.
Oh, and Your Honor, one second thing. Move for a directed verdict entirely on all claims against Georgia Power. But as a secondary issue, we would also move for a directed verdict to the extent the court denies the entire directed verdict on future medical expenses. That has been excluded, the cost of the surgery. However, given that how the evidence has come in and the fact that there has been no actual evidence of that surgery and the cost, we would say that the jury cannot consider the cost of that surgery in awarding damages in their consideration.
Got it.
Thank you, Judge.
You're welcome. Thank you for that. Mr. Ramsey, why is a directed verdict on everything not appropriate?
Good morning, Your Honor. It's for the same reason that Your Honor denied the earlier motion for summary judgment. This is more like a case where one side says the light was green, the other says the light was red. As Your Honor knows, there's been a lot of discussion about this fog line, which is the drivable portion of the highway. There's that little bit on the other side where the driver's not supposed to go. Now, again, the code section also says, fair enough, says that the pedestrian is supposed to stay out of that roadway as well. But you have some overlap there. There is a code section right on point. It's one of our requested jury charges, Your Honor, 40-6-93. In Georgia, every driver of a vehicle is required to exercise due care to avoid colliding with any pedestrian upon any roadway, not just in a crosswalk, not just in a specified area. He's also required to give warning by sounding his horn when necessary. There's uncontroverted evidence that no horn was sounded here. Also required to exercise proper precautions upon observing any obviously confused, incapacitated, or intoxicated person. Obviously, our view is he wasn't intoxicated. Mr. Shackleford testified very clearly that his foot was, I believe his testimony was at the fog line or on the right-hand side of the fog line when he was struck. Now, was he staring down Mr. Morris and looking at exactly where the vehicle was going? No, but an inference can be made from that, hey, I was sure that I was on this side of the fog line. That's when I got hit. I was also moving away from the road at the time. I think the jury can easily infer that, okay, well, then the truck, taking all the inferences and the most favorable to the plaintiff, that, okay, maybe he did exceed that fog line. Maybe he did hit the plaintiff in this instance. So we think it's a classic case of where the jury needs to make that call on which side of the evidence they think is most likely to be true. If anything, Your Honor, it's actually gotten to be a better case in some respects, because we actually have some different explanations or different stories of what happened. So I think the jury can, in their role of deciding who's telling the truth, they can say, do we really believe Mr. Morris when he says that it happened this way, when earlier he said it happened this way? So that we think that goes into it as well.
Tell me what you mean by that. What are the different stories that are at play?
The one we cross-examined him, the handwritten note, Your Honor, basically says, hey, the two log trucks were coming the other way. When he's been here in court, he's elaborated on that and said, oh, well, I dodged it basically in and out of these log trucks. And on his earlier statement, that was nowhere to be found. That, seems like, just in my view, it seems like that would be something, you'd want to include in a narrative, but right after the accident, that, oh, hey, I was having to decide between hitting these log trucks or hitting this pedestrian. It's also very clear from what Mr. Moore said that it's not like just out of the blue he hits someone. He knows that someone's there, turns to the left, then turns it back to the right, and that's when the collision happens. So that's a very different situation from someone just suddenly darting out in front and, man, I didn't even have time to do anything.
Okay.
And Your Honor, on the future medicals, obviously Your Honor's already ruled on the future medical surgery, the specific surgery. We're not putting any specific numbers in front of the jury to consider, but I mean, obviously, even as Dr. Barito alluded to, he's going to need some level of future care. We're not going to try to present in front of the jury and say it's $100 or whatever it is, but I think they're entitled to know there is some future medical treatment that will be necessary in some amount.
But future pain and suffering, the jury gets to quantify that. And it's not guesswork, it's their enlightened conscience and whatnot. That's what we say instead of guesswork. Future medical expenses cannot be speculative in nature. And the only number I'm aware of that you were in a position to hang on future medical expenses has been excluded because there wasn't a witness who could get that evidence in, whatever the reasons were that, oh, no, it wasn't that, he probably could have gotten some kind of certification from Emory. But your client has said, under oath, I'm not doing that surgery.
Right.
And so whether it costs $1 million or $5, it would not be appropriate to get the jurors to start to think about Georgia Power needs to make Mr. Shackleford whole down the road at some point because he's gonna get that surgery. He said the opposite. Not even I may get it. I'm not. I'd rather have my foot and have it hurt than risk losing.
Right.
So how do you get past it can't be speculative, the medical expense figure? There was testimony, the doctor cleared a lot up for you. And he did say, yeah, he's gonna need to, and I think your client said, I still go see doctors some. We don't have dollar amounts, so they would be guessing as to what that would cost.
That's a fair point. Perhaps it's just more lumped in with the future pain and suffering as opposed to anything else. I'm certainly not going to try to say, oh, every doctor appointment he's going to go to is this much, and you ought to. That's definitely not where we're going with this.
I assuming I deny the motion for directed verdict, process that, answer you in a minute. I don't intend to say that you cannot argue for any future damages, but I will likely say you cannot argue for future medical expenses because that would be guesswork at this point. There is not a fact you can point to in there other than to say, look, the doctor's appointment 6 months ago cost $150. And so you could say, let's discount it, just say there'll be $150 in the future, because of course there'll be more in the future. But we don't have a doctor saying I'll see him, and we really don't have your client saying I'll do it on this frequency.
Okay.
The pain and suffering, I think there's ample evidence for you to argue and a jury to find that persists, it carries forward, hence my ruling on the mortality.
Okay.
All right, so a directed verdict is an extreme remedy. It's appropriate to ask for it. It takes from the jury the job they've been impaneled to do, and the standard is appropriately high. I have to conclude that there is absolutely no conflict in the evidence, and any question we've got, I need to construe most favorably to Mr. Shackleford. I don't think if a jury came back with a verdict that says Georgia Power is in some way liable to Mr. Shackleford, it would be based solely on speculation, assuming we keep out future medical expenses. It might be surprising to get a verdict where the jury finds Mr. Shackleford in no percentage partially liable. It wouldn't be surprising to have a jury come back and say 75% liable, in which case there'd be no damages awardable. But I don't find that the record as it stands now is such that the jury would be engaging in pure guesswork to say Mr. Morris somehow failed to exercise the level of care that is a reasonable person would driving a 33,000-pound truck when it's dark. When his testimony is, I really didn't see this guy in my headlights until that last split second. For the testimony that he was standing back and forth. But in contrast to the case that you cited for me, Ms. Peeler, the Hunsucker, the 304 Georgia Appeals 200, which one was a summary judgment case, but two, it involves a driver who's cresting a hill, and just at the crest of the hill, someone darts out into the roadway. Under the uncontested facts of that case, there was no chance for a driver to react. So I understand the evidence, and I'm happy to be corrected if I'm getting this wrong. We're on a straightaway, it's not a twisting road, we're not cresting a hill. It's dark, but we're on a straightaway, and Mr. Shackleford has not said, I leapt in the direction of the truck. To the contrary, the only movement he acknowledges making is trying to evade the truck. So he is on a straight course down 106. His back is to the truck. That may inure to the defense's benefit when the jurors are weighing relative liability, but he is traveling in a straight line and he tries to get out of the way. This truck is traveling in a straight line, and somehow its headlight beam doesn't pick up anything until there's a silhouette at the last second. I think the jurors are free to weigh all that and say, maybe both parties were not exercising the level of care that a reasonable person would under that situation. but it wouldn't be unreasonable and it would not be based only on speculation. In other words, it would be based on facts and evidence that they've heard to say the driver here wasn't exercising a reasonable level of care such that he even had to swerve to begin with, as opposed to pounding on the horn or something like that. So I don't think it's beyond the jurors' reach to rely on evidence to reach a conclusion that there was some negligence on the part of Georgia Power. Will they do that? Don't know. That's not my question. That's not the question that's posed by a motion for directed verdict. But because I think they could and not be doing that in a purely speculative basis, it would be error for me to grant a motion for a directed verdict. So I will deny it writ large. I will certainly grant it, as I've hinted at, in connection with future medical expenses. Please, Mr. Ramsey, don't argue for or hint that the jury should consider future medical expenses. The only thing on a going forward basis you can urge them to award would be pain and suffering and not medical expenses. Those are quantified. I don't know if the math is accurate or not because I haven't tried to have the numbers on the summary sheet. That's your universe of medical expenses. Okay.
I think we did reach an agreement that my math was correct. Okay.
Either way, I'm just letting you know that whatever those numbers add up to, those are your medical expenses. It's not that plus some number of jurors that you're going to arrive. Okay. Ms. Peeler, anything more you want to get on the record in connection with your well-argued motion for directed verdict?
No, Your Honor, I understand the court's ruling, but we take exception to it.
Noted and preserved. Mr. Archer, we're going to bring the jurors back after we give Ms. Fuse a quick break. Are you calling any witnesses?
We will call witnesses. I'm retiring until closing, and Ms. Peeler will call, our first witness will be Janie Holmes.
Okay, and the witnesses that you need are, we're going until 6.
They're in the hallway.
Fantastic.
We're here. We have one deposition to play of Officer Maloney, and as we've seen, Ms. Peeler can run the machine.
She can. That may be our go-to person for both sides. Okay, let's take in a moment, we'll take a 5-minute break. But it sounds like Ms. Peeler, you'll be calling Ms. Huddleston next.
Yes, Your Honor.
Great.
We did have one in the nature of a motion. So they originally did it as a deposition designation for Ms. Huddleston. So I responded in that way and said, look, this portion should be excluded in my view. Ms. Huddleston says that in her opinion that she thought Mr. Shackleford appeared to be intoxicated as he was walking down the road. Don't have any issue with her saying, hey, I thought he was acting strange or he was waving his arms around. My issue is her saying the word intoxicated, which is a loaded word, when she's just driving by on the road, sees him for maybe a few seconds and makes that conclusion, especially.
As opposed to he was moving erratically.
Yeah, she can say, I don't have any objection to her saying whatever her specific observations are. My issue is, as we've seen, the jury's very concerned about was anybody intoxicated here? And so when she says that word, that's a loaded word that says you have alcohol going through your system, especially in the light of some of the other testimony we've heard. She's not a medical doctor. She's not making any kind of medical examination of her. I would ask that she be instructed not to use the word intoxicated. She can talk about her observations, but not that word.
Thank you for flagging that. Mr. Peeler.
Your Honor, I'm looking at a case. It's Dagny versus Schroeder, 336 Georgia App 36, 2016 case. Fact witness may testify on the basis of their personal observations regarding whether someone appeared intoxicated. Do not believe that someone has to be a medical doctor to give a layperson opinion on whether someone appears to be intoxicated based on their perception of that witness. I think Mr. Huddleston, 1, has not testified yet, and 2, she is a layperson who has layperson experiences, and if she had the opportunity to perceive Mr. Shackleford, it is fair for her as a layperson to testify as to her perceptions of him.
Hold on. Okay, gosh, that is exactly what that case says, and it points to other cases, and even Professor Miller's, so it's got to be right. What is your response to that?
I haven't had a chance to look at the cases, Your Honor. I would, my guess would be most of those cases involve people who were maybe from me to Mr. Archer, who were able to say, man, I smell alcohol in his breath, or he's acting he's slurring his speech. You know, she wasn't even in, she was in a closed-in car driving by this man, maybe saw him for a couple of seconds. How can you make that judgment call? And I think it's especially unfairly prejudicial because of the issues we've been talking about. For someone to come in and say, yeah, he appeared intoxicated. Again, I don't have any issue with her saying what the objective facts were that she observed. That's all fair game. And the jury can make any inference they would like from that. My issue is her being able to say, oh, he appeared to be intoxicated to me when, and she didn't, you know, say she hadn't testified yet. I mean, she gave her deposition. That's her world of experience, was a couple of seconds on the road as she passed Mr. Shackleford on the other side of the road. So I just think it's unfairly prejudicial. I think those other cases, while I haven't had a chance to look at them in detail, I think they're going to be distinguishable. It's just going to be somebody who was at least maybe in the same room as somebody, or sitting at a table over from them, or had a little bit more time to make that assessment. I don't think the uncontroverted evidence that she's going to offer is that she only had a couple of seconds in a closed-in car.
May I respond briefly?
You may. So I'm just looking at the Dagny, DAGNE case, and it is Maxwell, who's not a party to the lawsuit, who testifies that Dagny appeared to be drunk, and Maxwell said he had simply seen Dagny doing some driving, and the thing was swerving a bit, whatever vehicle Dagny was driving, and then there was a real bad accident caused by Dagny. And Maxwell rendered aid to a few people and real briefly interacted with Dagny. Dagny was just sitting there. So what do you want to add to that?
That goes to weight, not admissibility. I think he's free to cross-examine Ms. Huddleston as to the length of time she perceived Mr. Shackleford.
I think that's right. I think that what Dagny stands for in the cases it relies upon, and Professor Millage, is that a lay person, if it's based on personal observation, is able to offer an opinion about whether someone appeared to be intoxicated on a given occasion. As long as that opinion is based on personal knowledge. I was there, I saw this person, and they state a factual basis for it. You have identified a number of reasons why it's a particularly feeble factual basis, but you can explore that on cross-examination. And I appreciate that from your perspective, drunk or intoxicated is a radioactive term. But if that is the impression that Ms. Huddleston had, and there's a basis for it, i.e. she observed your client, even if in passing, she is entitled to share that if the foundation is laid, and it sounds like it will. So I'm going to allow her to answer those questions. You should still object when you hear them and say, Judge, I'm objecting to this line of questioning as we discussed, and I'll say you preserved it, but based on my ruling, I'm going to allow Ms. Peeler to explore this with this witness.
Okay, fair enough. Thank you, Your Honor.
You bet. Anything else?
Not for the plaintiff, Your Honor.
Okay. Ms. Hughes, if I ask you to be back, we'll go off the record. If I ask you to be back at 4:35 in about 5 minutes, is that enough time for you, or do you want, we have more if you need?
No, that's good.
Great, let's be back in 5 minutes, please.
This is fun. You doing all right? You all right?
He was getting dizzy.
Oh, no. You okay? Are you gonna be able to, I want you to be able to hear what's going on. You all right?
Yeah.
Need some water or anything, or?
He's got water in the bag.
Okay. Are you good to, do I need to?
I've got,
It's overwhelming.
got dizzy. I had to
Here,
hang on to the
Here.
wall.
sit down. This is just all overwhelming. It really is.
Huh?
It's overwhelming. It's a lot. Just
Oh,
keep
yeah.
breathe.
How's everything with you?
Okay, just breathe. You're hyperventilating yourself. Just calm
Sticky
down.
notes.
No, eat that other one. I'm sorry.
What I missed?
No, just,
Well, the case is still going.
yeah. they're trying
So
to
when,
throw
when we
the-
rest, the other side has an opportunity to say, hey, Judge, we want you to throw the case out. So that's what they did. And he said, no, I'm not gonna do that.
Yes,
So he did say he's not gonna let us, he's gonna exclude anything about future medicals, which we already.
yeah,
kinda did.
that's okay.
All right, so that's where we're at.
But,
And
and
then the
then
other
they're
thing-
gonna, the drunk thing.
Yeah, the other thing
That's
about
okay.
that she
You
thought
got
he was intoxicated or whatever.
Yeah.
So
But the,
she didn't notice.
the lady, remember? And that's okay, just take
That's
calm.
what she said. She said you appear to be.
Yeah, but
That was
like,
never in none of the hospital. I mean, they.
I know.
yeah, but what he's gonna tell them
Yeah.
is that your alcohol test came back negative. You're overstressing yourself, okay? You're overstressing yourself, just breathe.
I know, but they're making shit.
No, you're in church, you're doing good. Don't slow down, just keep yourself together, okay? You're fine, you're fine. Okay? You're gonna hyperventilate. Pass out, it's not good.
I'll stay until I'm relieved.
Everything's on your side. Chris is fine. I don't know. Breathe. And just calm down. Okay? Just calm down, okay? It's gonna be okay, just calm down. It's okay, we just put it in the bag. You just need to calm down. Everything is okay. I know that you're doing what you gotta breathe. We're going to the home stretch, honey. Just keep yourself together. Good. And people open stuff up here. I'm just opening it so you don't have to open it, but just calm yourself down.
I'm trying.
You have to just breathe. Because Chris is tired. Let him do his job. Just calm down.
Are they on, are you gonna call me again, Chris?
No, you're done.
No, you're done.
You were done, buddy.
You just have to drink this and stay calm. Okay?
God, I knew I should have brought some CNAs. You can't eat. Muffins or anything, Chris?
No, I'm good. I don't usually eat while this stuff's going on.
No.
I'm not gonna do it. I thought I could.
Your Honor.
Sir, let's make sure we're on, do you need this on the record?
No, I just
No.
wanted to ask some protocol. Janie is right outside. I can bring her in or leave her out until the jury's seated. How would you prefer?
Why don't you just have her sit
Okay.
at one of the benches here, so it's faster, shorter commute. That's a big sit. Are you ready to go?
Yes, I am.
All right, let's get on the record. Mr. Ramsey, are you ready for the jury?
We are, Your Honor.
Okay. Ms. Peeler, ready for the jury?
Yes, Judge.
Great. Deputy Gordon,
Yes.
we're ready for the jury if they're ready.
All right, observe.
She's the one.
Thank you, Deputy Gordon. You guys get a medium score for picking different seats. It's not a mandate, it's only a recommendation, that's all I can do. Ladies and gentlemen, the plaintiff has rested, so you've received all the evidence from the plaintiff's side. The defense has an opportunity to present a case if it wants to. I'll remind you that the burden is on the plaintiff to prove his claims by a preponderance of the evidence. But that doesn't mean that the defense can't try to disprove them or present whatever it wants to present. So I'll start by asking Ms. Mueller if you're going to call any witnesses, and if so, who that first witness is.
Yes, Your Honor, defendant George Power calls Jamie Huddleston.
Ms. Huddleston, if you'll come up, please.
Before you say, can you raise your right hand? Do you swear or affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth alone?
Yes,
Please lower your hand, have a seat. State and spell your name for the record.
sure. Jeannie Huddleston, JeanieHuddleston.
Good afternoon, Ms. Huddleston. How are you?
Good, thank you.
Can you tell the jury, where do you live?
I live in Toccoa, Georgia.
How far away is that from this courthouse?
2 hours and 4 minutes.
And did you want?
Not that I counted.
And did you want to come down here and talk to the jury today?
Yes.
Can you tell the jury just briefly a little bit about yourself? What do you do?
I've never heard a witness say yes. This is great. I want to savor that, because I get lots of. All right, thank you.
Can you tell the jury just a little bit about yourself, where you're from, what do you do?
Sure. So I live in Toccoa, Georgia. It looks very different than Fulton County. I'm from Atlanta, though, previously. I am the instructional specialist for the Futures program. We're a part of GNETS, which is the Georgia Network of Educational and Therapeutic Supports for Students. I have a daughter that's in high school, and that's about it.
And Ms. Huddleston, we told the jury we were going to be quick and efficient with this, so I just want to get right to the point. We're here to talk about an accident that happened in Stevens County on Highway 106 on August 12th, 2019. Do you recall that?
Yes, ma'am.
And first, generally, tell the jury, how familiar are you with Highway 106?
We moved to Toccoa in 2015. It's the road that I have to take to get to town.
Do you drive on Highway 106 daily?
Multiple times a day.
Are there any streetlights on Highway 106?
Absolutely not.
Are there any sidewalks?
Absolutely not.
Is it a 2-lane road?
Yes.
Do you typically see pedestrians walking along Highway 106?
No, ma'am.
What's the speed limit on Highway 106?
55.
And I want to talk to you about the morning of August 12th, 2019. Can you tell the jury first, what time did you leave your house that morning?
4:45. I was headed to the gym to take a workout class.
So you're an early workouter?
Yes.
Where was your workout class at?
It's located on Big A Road in Toccoa. So to get there, I'd have to take 106 to get to town.
What time did your workout class start that morning?
5 a.m.
Okay. Do you recall what the weather was like that morning?
It was not raining. Obviously, the sun was not out. It was dark. I don't remember clouds being cloudy or foggy.
And can you tell the jury what you saw that morning as you were driving to your workout class?
Sure. So as I was driving to class, I kind of went around a curve and I noticed that there was a man walking on the inside of the white line. I'm a runner and I would not walk or run on the inside of the white line, nor would I do it with the flow of traffic. The person was in the side of the lane going with the area of traffic. And I would not do it with dark clothes on or no reflective gear.
And do you recall about what time you saw that person?
It was about 4:45.
And do you know that was about the time because of what time your workout class started?
Yes, ma'am.
And so do you recall, I know you might not remember north-south, but with which direction were you traveling on Highway 106?
I believe it would be north. I was going into town.
And was the man that you saw in your lane or the opposite lane of yours?
The opposite lane of mine.
Was the man walking in the lane such that his back would have been to traffic?
Yes.
Was the man that you saw that morning Mr. Shackleford?
Yes.
I'm going to show you what will present as an exhibit, which has already been admitted into evidence. Ms. Huddleston, do you recognize this as a portion of Highway 106?
Yes.
And I understand that this might not necessarily be where you saw Mr. Shackleford. Is that right?
That's correct.
But I think you may have a touch screen on your monitor if it's working.
Okay.
And knowing that this isn't exactly the part of the road that you saw him in, could you mark for an X where in the road itself he was when you saw him?
So what you need to do first, tap the screen once, and then see that little pencil in a circle way over in the corner, lower left-hand corner, tap that. Now your finger is a pencil.
And was Mr. Shackleford alone when you saw him?
Yes.
What was your perception of how he was acting?
It was strange. I have gone to work out since 2019 at 5 a.m. He's the only person I've ever seen walking with the flow of traffic. It was really strange. He was kind of moving his arms, just really weird, not typical.
Did he appear like he was acting like he could be intoxicated?
Objection, Your Honor.
Okay, we discussed this outside the presence of the jury, and your concerns have been preserved for the record, overruled.
You can answer.
I would say yes.
And what was kind of his body movement when you saw him?
Just kind of flailing, walking in the middle of the road.
And you passed Mr. Shackleford and go to your workout class, is that right?
Yes.
Did you have to swerve around him at all?
No.
Did you pass any other traffic or cars in the area on your way to the workout class?
No.
And tell me what happened when you left your workout class.
So when I left the class to come back, traffic had stopped at this point. So in the picture, you can see the church. The road that I live on is directly across from the church. When I was coming back from the gym, there was the Georgia Power truck. There was an ambulance. There was police. Traffic was backed up. We did go around into the other lane to go back to my house. I got dressed, took my child to school. Everything was still there. When I came back from taking my daughter to school is when I pulled over and spoke with the public safety officers.
And I want to back up a little bit because your mention of the church reminded me, where in relation to the church that we see on this photograph, did you see Mr. Shackleford on Highway 106?
So from the church, ish. To the bypass is about 6 miles. And I'd say it was a good 3 miles from here where I saw him.
Okay, so you saw him about 3 miles from here, and then when you were leaving your workout class, you came back, and this is the area that you saw the police officers in.
Yes, ma'am.
Okay, and I think I might have cut you off. So you went and talked to the police officers, and what did you tell them?
I just told them what I had witnessed at 4:45 in the morning. I said I didn't, know what had happened, but here's what I saw previously. I just felt like I was obligated because I saw something to share it.
Now, a lot of people would probably have just kept driving and went home. What made you feel obligated to stop and talk to those officers?
Being a teacher, I feel like I'm a mandated reporter. If I see something, I say something.
And did you ever call Georgia Power after this accident?
I did. I spoke with a gentleman at Georgia Power. I don't recall his name.
And why did you feel the need to call Georgia Power?
I just felt like something had gone wrong. And as somebody who saw something, I just needed to continue to speak what I saw.
And did you know Mr. Shackleford prior to this incident?
No, ma'am.
Did you know Eric Morris, the bucket truck driver, prior to this incident?
No, ma'am.
Have you and I ever met prior to me taking your deposition in this case?
No, ma'am.
After this incident, did you see Mr. Shackleford again?
Yes, ma'am. He came to my home.
And tell the jury about when was that?
It was after the accident. He came to my home and wanted to thank me for stopping. It made me feel very uncomfortable, and I excused myself. And my husband proceeded to talk with him, but I felt very uncomfortable and went back inside my home.
What about it made you feel uncomfortable?
I didn't know this person, and I just felt like the way he was acting when I saw him in that road, I did not want that at my home.
Do you know how he got your address?
I would assume he got it from the police officers, from the police report, but I don't know.
Do you ever see Mr. Shackleford in your neighborhood, like he may be a neighbor of yours?
I don't live in a neighborhood, but we just live on a road, but no, I've never seen him previously.
And did Mr. Shackleford come to your house on one occasion or 2 occasions?
It was 2 occasions.
Okay, so can you tell us kind of the first occasion that he came to your house?
The first occasion, I did not answer the door. I stayed inside my home and pretended like I wasn't home.
And why was that?
Just don't come to my house if I'm not expecting you.
Did you know who was at the door when you didn't answer it? Or, in other words, did you recognize this was the gentleman that I had seen walking down 106 and then later on the side of the road?
No, sir. I just recognized it as a strange man at my home.
Okay, so it was a stranger to you. It wasn't, hey, that's the guy.
Correct.
And then did he come to your home a second time?
Yes. And
is that the time when you excused yourself and your husband spoke with him?
Yes.
Do you know what he wanted to thank you for?
No, I really felt very uncomfortable and did not stay very long. And my husband knew, so he tried to wrap things up so that he could also go back inside our home.
Is there anything else that you remember regarding this incident that you'd want to tell the jury today?
I think that's all.
Okay, thank you.
Ms. Huddleston, good afternoon. Sorry, I keep assuming it's morning, so we started a little bit late today. How are you doing?
Good, thank you.
Thank you for being here today. How long would you say you got to see Ron or this person you're describing that was in the road that morning?
As I was driving past, maybe a minute or so from the time my headlights saw him until I passed by.
Okay, a full minute, you'd say?
Or probably, less than a minute or less.
Like 45 seconds?
Sure.
Okay. Oh, okay. Got to see him for a little while then. Okay. So you had no problem seeing Ron, or I'm keep saying Ron because I'm going by what you told us, but you had no problem seeing this individual in the roadway, right?
Correct.
Okay. You had no problem seeing what the person looked like?
It was a man walking in the middle of the road.
Okay. I thought, okay. And where you marked your X, you would describe that as the middle of the road?
In the inside of a white line, yes.
Okay. And you're confident that the same person you saw walking at that spot in the road at that time of the day is the same person that is sitting right behind me, Mr. Shackleford?
Yes,
Okay. When he came to your door that day, you didn't know it was the same person?
not the first time.
Okay.
The second,
The second time you know who it was.
he identified himself at my door.
When he told you, I'm the guy who stopped by when I was on the side of the road, then you knew who it was, not because he showed up a second time.
Correct, when he identified who he was.
Now, and to be clear, when you stopped by, and I think you said you talked to the police, did you get to interact with Ron Shackleford at all at that time?
No, it was just two public safety officers.
Okay, so I just want to make sure we're clear that your experience with seeing Ron Shackleford was this time, or what you think was this time you believe you saw him in the road?
Yes,
Okay, and then you say he came by your house a couple of times after that?
yes.
Okay. Ms. Ellison, you don't have any medical expertise of any sort, do you?
No, sir.
Okay. Have you ever had an opportunity to review any of Ron Shackleford's medical records?
No, sir.
Okay. You mentioned that you thought he looked like he was intoxicated. Have you had any opportunity to look at his blood alcohol test results from the hospital?
No, sir.
Okay. Would you be surprised to learn that those blood alcohol test results came back as negative, or as I believe it said less than 10?
I'm going to object to that. I think that's hearsay from the medical record.
This is what
So
it states.
if you want to relate literally what it says, then you can do that. So why don't you rephrase the question?
I'll try to ask it a different way, Your Honor. Ms. Huddleston, do you assume that if somebody's out at 5 a.m., that person must be intoxicated?
If they are waving their arms and walking with traffic, then I would assume something is different or wrong with them, yes.
Okay.
Would not be common for someone to be out at that time walking.
You would agree that people go out running in the early morning hours, go out walking in the early morning hours. There's nothing that dictates that person must be intoxicated, right?
Sure, I run early in the mornings, but I run facing traffic. My mom taught me if I want to be hit, I should probably see the car coming towards me. So I would run facing traffic. I also have a flashlight that I wear on my wrist, as well as reflective clothing.
Okay. And you don't have any knowledge of the circumstances that led Mr. Shackleford to be out and about that time in the morning?
No,
You mentioned you would not assume, you don't assume that someone's under the influence just merely because they're out that time in the morning, right?
correct.
Okay.
But a runner wouldn't have been flailing their arms.
Okay. I'm going to show you what's been marked in your exhibit, or is your deposition. This is page 17. Do you see?
Chris, can I just have a copy of that?
What's that?
Copy of the deposition.
Oh, yeah. Well, I unfortunately, I think I only have the one copy of.
Well, don't show it to the witness until you've shown it to the lawyer first.
Oh, I'm
She
sorry.
knows what you're doing. Sure.
This will be from, just so you all know, this will be from page 17, line 17. So I'll hand you my copy. If you could just refer there to page 17, line 17. What was the question there?
What was your perception of him that he appeared to be intoxicated?
And what was your response?
I would say if someone is out that early, they're definitely under the influence of something.
Okay, so somebody's just out and about that time in the morning. They must be under the influence of something, right? In your view?
Walking on 106, probably yes.
Now, Ms. Huddleston, you mentioned, I think you mentioned earlier that when you saw this person out in the roadway, it concerned you, right?
Yes,
Okay. And it concerned you so much, did you call 911?
I did not.
Ms. Huddleston, you described your interactions with Georgia Power and their attorneys. You You went out of your way to go reach out to Georgia Power and say, hey, here's what I saw, right?
Yes.
Okay. When my office contacted you and told you we represented Mr. Shackleford, you didn't respond, did you?
So my first impression of you, you sent me a Facebook message, and that's clearly very unprofessional, especially with somebody in your position. You did send me a letter. However, the first impression was a Facebook message.
Would you fault Mr. Shackleford or his attorneys for reaching out to you to find out what you knew about the case?
Via Facebook, yes.
So you made sure to respond to Georgia Power and actually went out of your way to talk to them when our office and Mr. reached out to you, no go, right?
Correct. So your client could get my address, but you sent me a Facebook message. That's very unprofessional for somebody in your line of work.
And you admitted you did get a letter from us, right?
I did.
Now, Ms. Huddleston, I think you said that when you were going to your fitness class, if I remember your testimony correctly, this photo we're looking at here, this road here, the New Hope Road?
So the church is called New Hope Baptist, and across from New Hope Baptist is New Hope Road.
Okay. And do I understand correctly, you live off of that road somewhere?
I live on New Hope Road.
On New Hope, okay. Do you know that Gully Road is on or off of New Hope Road as well?
Yes.
Okay. Did you know that Mr. Shackleford lives on Gully Road?
No, sir.
Okay, so did you know that Ron's actually one of your neighbors?
No, sir.
Okay. So when you stopped by the first time, you had no idea who this person was, right?
Just a strange man at my house. Correct.
But today you're able to say, yeah, that's the same guy that I saw on the road.
When he came to my home and identified himself as the person that was in the road.
Is it fair to say that you learned that someone had been hit in the road and you said, that must be the same guy that I saw? Is that fair?
When he came to my home and identified himself as a person that had been hit in the road.
Right, but he didn't know, he didn't see that you had seen him or seen whoever an hour earlier, right?
Correct. I did not see him that particular day.
Okay.
I'm curious if I had showed up at your door 3 days ago, knocking, said, would I be described as a strange man also because you don't know me, or there was something about what Mr. Shackleford was doing that caused you to say it's a strange man? Strange as in unknown, or strange as in something was going on?
Strange in as unknown.
Okay.
Now you mentioned there was a second time Mr. Shackleford and a lady came by. Did you understand who the lady was? Or
I don't remember there being a lady with him.
and I believe you said your husband was out there and was talking with him.
Yes.
Okay. And then he called you out to come talk with Ron.
Yes, my husband was in our yard working and asked me to come from inside.
Okay. And I believe what you testified Ron said to you was, hey, thank you for calling 911 or for calling somebody to come check on him, right?
He just said, thank you. I don't remember him saying that I had called 911. I had not, so.
What made you feel uncomfortable about somebody coming by your house and saying, hey, thank you?
It just made me very uncomfortable given the way that he looked when I saw him in the road that day. Like something was wrong with him.
Did Ron say anything that was of any kind of intimidating or threatening nature to you that day?
No.
And just to be clear, I want to make sure I understand. You said you saw Ron, or you saw whoever this was in the road, a good 45 seconds before you got to him.
I would say by the time my headlights entered into where he was, and by the time I passed him, maybe that much time.
Okay. And you said the weather was clear, no rain, no fog, anything like that? You had no trouble seeing him whatsoever?
No, sir.
That's all I have at this time, Your Honor.
Anything else for Ms. Huddleston?
No further questions.
All right, ladies and gentlemen, any questions for Ms. Huddleston? Yep, we do, okay. Got a signal, I can't read mine. Deputy Gordon, if you would, please. A substitute question. So a few more questions.
Sure.
The first time you encountered Mr. Shackleford while you, and I know you didn't know who he was at the time, while you're driving, for how long were you able to see him before you passed him?
I would say from the time my headlights turned the corner, I could see him.
Okay,
At the time I had a Jeep Grand Cherokee.
okay. But if you were to hang a rough number on that from the time you turned the corner, meaning you got on 106? Or what turn, or it was a corner in 106?
Yes, sir.
So you rounded a bend on 106, and from the time you rounded the bend, you were able to see Mr. Shackleford. How long was he in your line of sight? So you didn't hit him until you passed him?
I would say maybe a half a football field.
Oh, I don't mean distance. I mean, how much time were you, I'm looking at this guy walking in my direction with his back to me.
I'd say 30 to 40 seconds.
And at that time, the first time you saw Mr. Shackleford, daylight, dark?
Dark.
No, not even dawn. It's dark out.
Yep.
Okay, you finish your workout, you're coming back, you see there's a situation with law enforcement and whatnot. Daylight, dark out, in between.
It was about 6:15, so sun coming up.
As in, it's not pitch black, there's some dawnish like light, or what do you mean when you say sun coming up?
So it would have been light.
And you answered my next question, was about what time was it that you observed the emergency vehicles there? I think you just said around 6:15.
Yes, the class was from 5 to 6.
Do you recall how Mr. Shackleford got to your house? In other words, was there a car in the driveway, or a truck, or a horse, or a skateboard?
I believe there was a vehicle, but I could not tell you the make or model or
Okay,
anything.
and that was the case both times he came to your house, that there was a vehicle in your, I don't know the approach to your house. If you have to climb steps, you couldn't see if someone's in.
I don't recall the first time, but the second time, I believe there was a vehicle. I just couldn't name the make or model.
Got it. And you mentioned you interacted with Mr. Shackleford briefly, and then your husband chivalrously got in there and let you go inside. Were you and Mr. Shackleford ever talking in your kitchen, or was it on a porch, or was it outside? Where were the two of you talking?
On our front porch, and he sat in we have rocking chairs, and he sat down.
Okay. Did Mr. Shackleford ever go into your house?
No.
Ms. Bueller, any questions based on this for Ms. Huddleston?
Yes, Your Honor, a follow-up question based on that. Ms. Huddleston, when you saw Mr. Shackleford in the road, were you traveling in the opposite lane as he was?
Yes.
So to be clear for the jury, he wasn't in your lane that you were driving in.
Correct.
He was in the opposite lane walking towards you.
Yes.
No further questions.
Mr. Ramsey, any questions for Ms. Huddleston based on what we just discussed?
Nothing further, Your Honor.
All right, Ms. Huddleston, thank you for the 2-hour and 4-minute drive down here. Appreciate your time.
No problem. Thank you.
Ms. Peeler, next witness.
Your Honor, we're going to call Todd Maloney via video deposition.
Okay, ladies and gentlemen, this will be a similar format. I don't know if Mr. Maloney speaks as quickly as Dr. Barreto, but it will be a deposition. Any sense of how long this deposition? I meant to tell you that the doctor's deposition was about 45 minutes, just so but it was 45 minutes. Actually 46.
This one's 30.
A little bit short. Okay. And I assume that Mr. Maloney early on in his answers explains who he is. You don't need to provide that. That'll come out during the deposition.
Yes, I think
Great. Okay. Maloney it is. Thank you.
And you currently live in Rabun County?
Yes.
So you said you were in law enforcement from 1995 to 2021, is that right?
Yes, I'm still certified. I keep up my training, so I keep my hours up and actively looking to go back.
And what are you doing right now as far as where you're employed?
I work at the Postal Service.
And in August of 2019, what was your job title at the Stevens County Sheriff's Office?
I was a patrol sergeant.
And as an officer at Stevens County or prior, did you receive training regarding responding to and investigating motor vehicle accidents?
Yes, I have.
And tell me just briefly a little bit about that training.
Basically, we had that in the academy, but over the years, working at Forsyth County I was there for, I want to say 14 years. We had in-service training. And then, of course, when the accident reports changed and we went from paper forms to digital and doing them on computer, they had us do different things. But over the years, working accidents has basically been the same. You look at all the evidence, you look at skid marks, you look at where things are, where they happen, where the evidence is, and you piece it back together and you take statements and put everything together and you come up with your conclusion.
And from just a general estimate, how many motor vehicle accidents would you say you've investigated in your career?
Well over 1,000.
Okay. And we're here today regarding an accident that occurred on August 12th, 2019, around 6 a.m. on Highway 106 in Stevens County regarding a pedestrian in a Georgia Power vehicle. Do you recall that incident?
I do.
And are you familiar with Highway 106?
Yes.
And tell me a little bit, kind of just describe what that highway is like.
It's a 2-lane highway. It's pretty curvy in some areas. This area where the accident took place is, if I remember correctly, the area you come out of a curve and then it's a straight, it's a little hilly, but it's still straight, because it's right at a church, maybe 200 yards past where the incident or the crash took place. On the left is a church, and I want to say New Hope Road is on the right, just past it.
Okay. Are there any streetlights on that portion of Highway 106?
No. There's some lights down around the church, but I don't recall any street lights.
Okay. No. Are there any sidewalks along Highway 106 of that portion?
No.
Okay. I'm going to show you what we'll mark as Defendant's Exhibit 3. And if you could just hold this up to the camera too. Is this a photograph of the area roughly around where you responded to the scene of this incident?
Yes.
Okay. And based on your understanding and your perception, is this an accurate photograph of a portion of Highway 106?
Yes, it is.
Can you kind of describe what you saw when you first arrived on the scene?
Saw a Georgia Power truck. I want to say there was the big Georgia Power, I want to say it was a bucket truck.
Okay.
If I'm not mistaken. And then I think there was a pickup truck also.
Do you recall whose pickup truck it was?
I think it was a Georgia Power pickup truck.
Okay.
But I cannot remember. I know, according to this picture, Exhibit 3, where this picture was taken, is a little closer to the church than where this actually happened. Because
Okay.
there's a driveway that comes from the back of the church back out to 106.
Mm-hmm.
That's where it basically occurred at, was at that fork in the road. I want to say fork in the road, but it was actually the secondary driveway for the church.
Okay. going to show you what we'll mark as exhibits 4 and 5, which are 2 other pictures. 4, and if you'll hold that up to the camera, please.
Yeah, because I think the extra driveway comes out where the truck is.
Okay.
And this is number 5.
Okay, so Mr. Maloney, I've shown you 2 photographs that were also taken from the scene, and you can see the Georgia Power truck in the one photograph. Is that right?
Yes, that's correct.
So do you think this was around the area of Highway 106 where the incident occurred?
Yes.
Okay. So you get on the scene and you see a Georgia Power truck and a pickup truck, and what else do you see?
If I recall correctly, I saw the driver of the Georgia Power. One of the Georgia Power employees was on the phone contacting his supervisor, if I'm correct. He was notifying somebody what was going on. Ambulance showed up. We checked on Ron because I do know who he is, and he was, if I remember correctly, he was yelling my name because I think I'm probably the only deputy he knew that worked there. Went over and he looked to be okay. He was laying on the ground. And I told my officers about directing traffic. One of the other officers went to Ron to help him. And then I believe, if I'm not mistaken, I want to say that I went ahead and started notifying Sergeant Lumpkin, or notifying dispatch to have Sergeant Lumpkin on the way, since he worked serious injury crashes, especially one with a pedestrian. And I believe I called for a trooper, or I may have called for the trooper on my way to the accident.
Okay, and you said you know the pedestrian involved Ron, and it's your understanding that was Ron Shackleford, correct?
Yes.
And tell me, how do you know Mr. Shackleford?
We went to high school together.
Would you say you're friends with Mr. Shackleford?
We're not close friends. I would more say acquaintances that we've known in this area. If you go to high school with someone, basically 40 years later, you still know them, know who they are. You see them in a different area, you're gonna speak.
Okay. But you weren't hanging out with Mr. Shackleford as
No,
friends, right? And so he was in the grass near this orange circle, and kind of, can you describe to me whether he was sitting down or laying down, or kind of what his body position was?
When I saw him, he was laying down on his side.
Okay. Do you recall what he was wearing?
If memory serves me correctly, I think he was wearing blue jeans, boots, and for some reason I want to say he was wearing a trench coat.
Okay.
Like a long rain jacket almost, but I cannot remember.
Do you recall kind of roughly what the temperature was? Was it warm, cold?
It was a chilly morning, and when I want to back up a little bit, because when I said I thought it might have been raining or wet out, I think what I was getting at was the dew on the ground in the grass. So it wasn't cold, but it was a chilly morning.
And did you talk to Mr. Shackleford when you got there?
Briefly.
Okay. Tell me about that exchange.
when I showed up, I remember hearing him saying Todd. So I knew it was him because he has a voice that you cannot forget. We all have a distinct sound, and Ron has a distinct sound when he speaks. So when I heard the voice, I knew it was him. And I went over, like I said, I checked on him, but one of the other officers went to be with him. I believe I told him that he was going to be all right, because one of the other officers was helping him, and then I walked away. And then the other conversation we had was when they were getting ready to put him in the ambulance.
And tell me about that conversation.
He was asking me to get something. I cannot remember if he was saying, get me my billfold, or where's my billfold, or if he was saying, get my pills. They both sound familiar, but I cannot remember exactly.
And when you arrived on the scene and saw Mr. Shackleford laying in the grass, what was your perception of how he was acting?
In my opinion, it wasn't a very serious injury. If he was, laying there, yes, he was calling out for me when we got there. And like I said, if I remember correctly, because the voice, but he wasn't passed out. There was no bleeding. There was no, deformations to his body or anything like that I've seen in the past of someone who's been hit by a vehicle.
And were you able to, when he was laying in the grass, see his foot?
Not right off. I think, if I'm not mistaken, EMS took the boot off, and when they took his boot off, it looked like there was a bruise forming on the outer edge of his foot going up towards his ankle.
Did you see any blood when they took the boot off?
I saw what looked like a scratch.
But no profuse bleeding?
No, there was no. There was no running blood.
Did you see any sort of bone sticking out of his foot or anything to indicate to your eye that his foot was broken?
No.
And when he was in the grass yelling your name, was he slurring his speech at all?
It's kind of hard to say because when he talks, he does slur sometimes. But that's, like I said, that's his voice. That's how he talks. He's not always, and nothing against him. It's just that's how he talks.
Did you ask him, or did you have any reason to know why he was on Highway 106 around 6 o'clock in the morning?
I think I did ask him that question, and he said that, I want to say he said a car broke down or something, so he was walking home.
Okay.
I know he told me he was walking home, now that you say that. And I think I asked him why he didn't call somebody, and he said everybody was asleep, so he was trying to make it home, if I remember correctly. Now, my body camera would have accurate depiction of that.
When you were on the scene, did you see any evidence that the Georgia Power truck crossed the fog line onto that shoulder?
No, I didn't see any evidence of that.
Did you see any evidence when you were on the scene that the Georgia Power truck left its lane of travel onto that shoulder?
No, I didn't see any tire marks in the grass or anything like that.
And is that something that you would look for as a trained law enforcement officer?
Yes.
And if you saw something in the grass, would you have made a note of that to somebody?
Yes, I would have.
Okay. And were you a part of any investigation done by Georgia State Patrol?
No, I was not.
Good afternoon, Officer Maloney. My name is Chris Ramsey. I represent Ron Shackleford in this case. You testified earlier that when you first saw him on the side of the road, it didn't look like Ron was too bad hurt. Is that correct?
That's correct.
Okay. Would you agree? Did you do any kind of medical assessment of him to figure out what his injuries might be?
I did not do a medical assessment of him. However, he was laying on his side, and if I remember, I know I keep saying this, but if I remember correctly, due to the length of time it's been, he was on his side, but he was reaching down, trying to hold his leg or his ankle at the time, saying I think he said his foot was hurting. But also, I've been in public safety since I was 14, and I'm 50, and I was an EMT for 8 years prior to getting into law enforcement, and I was also in paramedic school up until I had 2 months to go before I dropped out to go into law enforcement. When I saw him moving the way he was, I did not feel like he needed a full medical assessment by me at the time, but maybe that of more recently trained paramedics. But if he was moving around and he was breathing and he didn't have blood spurting out, that he was fairly okay.
Okay, so when your definition of fairly okay would be, he seems to be breathing, he seems to be able to communicate, he's able to move around some. In other words, no life-threatening injuries, right?
Correct.
Okay, and would you obviously shortly after you were there, the EMS arrived and they were able to come pick him up and give him an assessment. In terms of his medical condition, would you defer to whatever the EMS folks looked at?
Whatever the EMS determined on the scene, since they did the physical check of him and I did not, that's up to them, whatever they determined. Yes, sir.
Okay.
I would defer to them.
Okay. You mentioned that there was not any blood flowing freely. Would you agree that someone can have broken bones, torn tendons, things like that beneath the skin that may not result in blood spurting out?
Well, yes, sir. I would say any internal injury, it's internal. You can't see it externally. True.
Okay. If in your experience, if a Georgia Power truck were to run over your foot, would it likely cause damage?
Yes, I do believe that a vehicle like that would cause some damage to your foot.
You mentioned that you had talked to Mr. Morris, who was the driver of the truck, right?
Well, I tried to, but he was on the telephone.
Okay, and I thought you said at one point that he had told you where the collision occurred and where he stopped, and that he backed up so nobody else would come up on the scene. Is that something he said to you, or maybe to somebody else?
I'll clarify. There was 2 Georgia Power employees there that I remember, and if I misled or misspoke that it was actually him that said it, I could be wrong. It was one of the Georgia Power employees, and it could have been him that told me he did that, or it could have been the passenger or the other Georgia Power employee. But I do recall someone saying they backed up so their lights would be there, and they would be behind where it happened.
Okay. And Officer Maloney, you said when you arrived on the scene, there was a Georgia Power bucket truck, and then there was also a pickup truck?
I believe there was a pickup truck there, and I believe it was a bucket truck, but looking at the picture, I can't tell if there's a bucket on there or not.
Okay. Did you have any understanding of which of those two vehicles hit Mr. Shackleford?
Yes, it was the big truck.
Okay,
I'll
the one that may have been a bucket truck.
Yes, we'll just say that the big truck is the one that possibly hit him, and the little truck was the one that somebody else was in, if I remember correctly.
Okay. So was there any explanation given for why this other Georgia Power truck managed to beat you to the scene of the accident?
If I remember correctly, I think they were both going there going somewhere together, maybe. I can't remember.
Did you find that at all unusual that someone else with the same company managed to get to the accident scene before the police and the EMS?
No, I don't really find that unusual, because lots of times, when I've seen power companies going somewhere, there's usually somebody in a big truck, somebody in a little truck. And it's just like with law enforcement. If you see one, there's going to be another. So in this instance, I don't find it suspect or odd that there would be two vehicles. But now, mind you, I could be wrong. That could have been just a regular F-150 pickup truck that somebody else was driving, and I didn't pay attention to it.
Okay. When you testified that there were some other Georgia Power employees there on the scene, right? Besides the driver?
I think there was two total. I think there was a driver and another one. That's why when I say I saw the smaller truck, I was thinking that was the other Georgia Power person was in that, or he could have been in the big truck with him.
Was there anything anybody told you that led you to believe that the big truck was traveling with the smaller truck?
No.
Okay.
It was an assumption on my part.
And Officer Maloney, I think I know the answer to this question, but let me make sure I understand your answer. Obviously, you were not there when the actual collision occurred, right?
Correct.
Okay. So in terms of actually eyewitnessing whether the truck left the road or whether Ron Shackleford was in the road, that is not something you actually witnessed with your own eyes, correct?
Correct.
Okay. And the opinions you've offered have been just based on your observations of what the accident scene looked like sometime later.
Well, yes, sir. And formulating my opinion on the reasoning behind knowing that the truck did not leave the roadway is, with the ground being moist, a heavy truck like that, dual wheeled, that's probably I want to say it's, being the heavy weight that truck is, there would have been tire marks in the grass, and it would have sunk in, and you would have seen probably two types of treads, because the rear axle is a dual axle. So you would have seen the front tire where it had gone off, and then you would have seen where the dual wheels had gone off the shoulder into the grass, and there were no tread marks or depressed grass along the side of the highway at that location. And also looking at the photographs, refreshing my memory, the tires aren't even dirty, and they would have had grass on them.
Do you know where the truck went after it hit Mr. Shackleford?
What I want to believe was told to me was that the truck backed, when it stopped, it backed up, so that way the headlights would be there. shining on them.
Okay. I'll
But they-
represent to you, there's testimony in this case by Mr. Morris that he went on down the road, turned into the church parking lot, and used that to get turned around and come back to the accident scene. Knowing that, does that change any of your opinion that the tires would necessarily have dirt on them if they had gone out off the road?
No, it does not change my opinion.
You believe the dirt, there would still be dirt left on the tires after driving that distance to get back to the accident scene?
Yes, sir. You're looking at maybe 200 yards to the church, and turning. If he did that, I was under the impression he backed up. Somebody told me he backed up. I thought it was him, but I'm completely wrong then, if that's his testimony. If he went through the church parking lot and came back and circled around, then that would not have been enough time to clean the tires and dry off. Not in my opinion.
And is there in those pictures you're looking at, is there a muddy area, or my recollection is it was a grassy area?
It's a grassy area.
Not there when the actual collision occurred, right?
Correct.
Okay. So in terms of actually eyewitnessing whether the truck left the road or whether Ron Shackleford was in the road, that is not something you actually witnessed with your own eyes, correct?
Correct.
And the opinions you've offered have been just based on your observations of what the accident scene looked like sometime later.
Well, yes, sir. And formulating my opinion on the reasoning behind knowing that the truck did not leave the roadway is, with the ground being moist, a heavy truck like that, dual wheeled, that's probably I want to say it's, being the heavy weight that truck is, there would have been tire marks in the grass, and it would have sunk in, and you would have seen probably two types of treads, because the rear axle is a dual axle. So you would have seen the front tire where it had gone off, and then you would have seen where the dual wheels had gone off the shoulder into the grass, and there were no tread marks or depressed grass along the side of the highway at that location. And also looking at the photographs, refreshing my memory, the tires aren't even dirty, and they would have had grass on them.
So your conclusion relies on an assumption that if the truck had gone off into the grass, it would have left some sort of visible mark, right?
Yes.
Okay. Looking back at that same photo, where the truck is parked, and I understand no one's saying that that's exactly where the truck was when it hit Mr. Shackleford, but you see the solid white line there, the
Yes,
fog
sir.
line.
I see the fog line.
What's the significance of the fog line?
The significance of the fog line?
Yes, sir.
It's to give the driver, basically, it's a painted line, and it's supposed to be reflective, like it's supposed to be painted with thermoplasty, from what I remember, that gives drivers, again, I'm trying to find the right wording. Basically, it's to show you the shoulder of the roadway, so you don't drive off the shoulder of the road.
Technically speaking, though, the vehicle is supposed to stay inside of the fog line, right?
Yes, it's supposed to be between the fog line and the center line.
Would you agree that if a driver sees a pedestrian, and let's just say for sake of argument, would you agree that if a driver sees a pedestrian in the road, he sees him, does that driver have a duty to take measures to try to avoid the pedestrian?
Yes, it's basically due regard for the pedestrian if they see them in time.
Okay. If a driver sees a pedestrian, does he have a duty not to turn his wheel toward that pedestrian in the roadway?
Yes.
Would you agree that a driver of a vehicle has a duty not to cause his vehicle to cross over a double yellow center line?
Yes.
You mentioned that you kind of did a general observation of the scene of the accident. Did you see any skid marks or anything to indicate that the truck tried to brake before it struck Mr. Shackleford?
I don't recall seeing any skid marks.
So Officer Maloney, when you first arrived on the accident scene, you were the most senior officer there, correct?
Yes.
And even if you're not the state trooper involved in investigating a crash like this, you're still using your experience and training to evaluate the scene, correct?
Yes.
And your training as an EMT and some training as a paramedic, you're trained to recognize injuries, is that right?
Yes.
Based on your training and expertise as an EMT, would you consider what you perceived as Mr. Shackleford's injuries being serious?
From what I saw, I did not see anything serious.
And have you investigated pedestrian accidents before as an officer?
Yes, I have.
And in your training and experience as an officer, have you seen pedestrians who have had serious injuries from motor vehicle accidents?
Yes, I have.
And compared to pedestrian injuries that you've seen as an officer, you would agree that you did not think, based on your perception of Mr. Shackleford, that he was seriously injured, correct?
Correct. I did not think he was. The opinion I gathered when I saw was he did not have any life-threatening injuries at the time that were visible.
And if a pedestrian is walking alongside a state highway like Highway 106, do they have a duty to exercise reasonable care for themselves?
Yes.
Would you state in your experience as an officer that it's dangerous for pedestrians to stride alongside a highway?
Yes, especially if you're going with the traffic flow instead of against the traffic flow, because your back is to the traffic that's approaching. You can't see to know if somebody's coming and to get out of the way.
And based on your investigation of this accident, was Mr. Shackleford walking with the traffic flow?
That's what it appeared, yes.
Officer Maloney, you'll find that hopefully these get a little shorter each time. Just to go back real quick, Ms. Peeler asked you a number of questions about whether Mr. Shackleford's injuries were serious. And I think I just want to make sure, based on our prior discussion, when you hear the word serious, do you equate that to mean life-threatening?
Yes.
Okay. So, for example, Mr. Shackleford has testified that several bones in his foot were broken, tendons torn, and he still walks with a limp 3 years later. Would you agree that's a significant injury?
I would say it's a significant injury if he still walks with a limp. Yes. That's damage to your body. Yes.
Right. Obviously not life-threatening, correct?
Not in my opinion.
Okay. Fair enough. Officer Maloney, you mentioned that you've stated that motor vehicles have the right-of-way. Does that, and I'll kind of ask it a different way than I did earlier. So motor vehicles have the right-of-way. Does that mean if I see a pedestrian in the road, I have the right to run them over?
No.
Ladies and gentlemen, I want to explain one thing about that deposition as well as the doctors. It may have seemed a little choppy. That's because just like in court, a lawyer can object, and if I sustain it, we stop that line of questioning. Lawyers in depositions can object, but they don't stop because there's not a judge there to rule on it. So lawyer X may have said, Mr. Maloney, what happened next? And there's an objection. and the parties agree, you've preserved it by objecting, but please answer it anyway, because if the judge overrules the objection, we need to know what that answer was. We can't call you up and say, wait a minute, he overruled the objection, what was your answer gonna be? So there were things that were removed because of valid objections that were sustained from both the doctor's deposition and this one. There wasn't secretive editing by one side that the other side didn't know. It's very standard for depositions to bounce around a little bit. So with that, we are at 5:45. Who is your next witness, if you have another witness?
And we have one final witness, and it's Jeff Kidd.
Okay, my guess is that's not a 15-minute witness.
No, it's not. It'll be quick, but we won't be done by 6.
Okay. My thought is that we keep the lawyers here to talk about the jury charge and we let the jurors go home. Let me look at tomorrow's schedule. We can start at 9 and keep doing what we were doing. Anyone have an issue with being here at 9 tomorrow? All right, you know the routine. Please don't talk about the case with others. No outside research. We'll see you here as close to 9 as you can make it, and we will take that last witness from the defense.
All right, good.
Let's do the vote at the time. I'd like to do some of the charge conference now. I have to vote for the next 15 minutes anyway, as long as Ms. Hughes can bear with us. Have a scheduling teleconference tomorrow at 8:30, so I can't start a whole lot before 9. But for everyone's scheduling purposes, we'll take the last witness. We'll see if there's any rebuttal. Do you envision there being rebuttal?
I'm sorry, to the expert witness?
Do you plan on calling any witnesses after the defense rests?
No, we don't, Your Honor.
Okay, got it. Then I'd like to try to get closings in before we break for lunch. Lunch, it has to start at 11:45, and it will run a little late because of things I've got going on, because I thought we'd be done before now. But if we could get closings in, maybe get charging, but we'll see. But folks should be ready to go straight into closings after the defense rests, if there isn't going to be any rebuttal. So have whatever you need in terms of PowerPoints and whatnot ready to go, assuming we finished our charge conference, so you know what the law is going to be that applies. Mr. Ramsey, anything else you need to bring up before we get to the charge conference?
No, Your Honor.
Okay. Ms. Bueller, anything else?
No, Your Honor.
All right, I'm gonna share screen and put the charge up. And let's start talking about it. You all want the charge conference taken down, or can we let Ms. Hughes go?
Probably prefer to have it taken down, if that's okay.
Sure call. All right, so you should have on the screen in front of you, as well as if you printed it out or you're pulling it up by way of before lunch today, the draft charge, which is based on pattern charges I have to give, along with the submissions from both sides. And what I propose to do is to scroll down to the first area where I have a question or concern. And if in doing so, I passed over an area where you had a question or concern, tell me, and we'll go back to where we need to. All right, so the first question I had is to do with approximate cause, at the bottom of page 4. I've edited the approximate cause charge a little bit. It is one of the least accessible charges that is frequently given on the civil side of things. And it pains me to give it as written, so I try to make it a little more accessible to the jurors. I don't think we need the sentence that I've struck through, because this case is about the truck striking Mr. Shackleford, and the damages were caused either by negligence on the part of Mr. Morris or by Mr. Shackleford, or a combination of the two. I don't think we've got an act or omission of anyone who's not a party to the suit at issue. There wasn't the driver that swerved in front of Mr. Morris, so then he swerved in the direction of, even more on point. It wasn't that the logging trucks veered into Mr. Morris's lane, so he veered to avoid them, and that's why he struck Mr. Shackleford. So, Ms. Peeler, I'll start with plaintiff on all these. Mr. Ramsey, any objection to omitting the struck through sentence?
We were in agreement, Your Honor.
Ms. Peeler?
No objection.
All right, I will get that out of there. Next up is straddling pages 6 and 7, charge about pedestrians on a highway. I don't think the sentence about when neither a sidewalk nor a shoulder is available, because we've seen many times now the photos of the strip of 106 that is most pertinent to the trial, and there's plainly a shoulder. It's a shoulder that is grassy, and so it may have snakes, but there's a shoulder. It's not that there's the roadway and then a cliff, so that the only viable option for a pedestrian was to walk, and I'll quote from the sentence I want to remove, as near as practicable to an outside edge of the roadway, or only on the left side of the roadway. That's not the situation we have. Do you agree, Mr. Ramsey?
Your Honor, we would appreciate Your Honor's statement on that, but we think it's within the jury's consideration to listen to what Mr. Shackleford said in terms of that he felt like the shoulder, for various reasons, was unsafe or was not suitable for him to be way off in the grass where snakes might be. So I guess if I was going to say a shoulder, I would also put in parenthetically, a safe shoulder. And so there were some concerns he had about that. And so obviously the jury could say, we agree, we think there was a huge shoulder here that he had to make use of, but he has said, hey, for these reasons, I don't think that was something I could make use of.
Right.
And so if that were the case, then then the other clause would apply.
The language isn't neither a sidewalk nor a shoulder that the pedestrian subjectively viewed as safe. And that's the scenario we're dealing with here. So I think it describes a scenario that factually doesn't apply to our case. It's not that there was no shoulder. There was a shoulder that was distasteful or potentially alarming to your client, but not that he didn't see it. He's testified that it was there, but because of snake bite, I didn't want to walk on that shoulder. So, but let me hear from Ms. Peeler. If she agrees with you, I don't want to exclude it over double objection.
We have no objection to the highlighted part being excluded, so long as the part above is included.
I'm only talking, it is included. The only thing that I think should be removed because it doesn't apply is the highlighted struck through portion. There's no objection from the defense.
No objection.
Okay, I understand your objection. I'm overruling that and I will exclude that. Damages duty to lessen. Ms. Peeler, tell me what the evidence is here that the jury could rely on that would support the notion that Mr. Shackleford has somehow engaged in activity that would not be the use of ordinary care in an effort to reduce his damages.
Your Honor, the jury's heard testimony from Dr. Berto that he was smoking, he wasn't weight bearing, he missed an appointment. I think there is sufficient evidence from what's been presented for them to include he's not obeying doctor's orders, therefore he may not be lessening his damages.
Okay, and I had not heard his testimony last night when I went through the jury charge, and I think that's sufficient to support this. I don't know how compelling that argument is, but there's certainly, you could point to several things Dr. Barreto shared with the jury today that would allow a juror to say, you know what, I think that the pain and suffering is X, but I'm gonna do 0.98 times X because Mr. Shackleford wasn't the perfect patient. Do you want to be heard on that at all, or do you agree, you may not like the charge? It's a perfectly legal, proper charge, assuming the evidence supports it, and I do think, based on Dr. Barreto's testimony we received today, it's appropriate to give it.
Yeah, obviously we disagree, but we can, I think they're allowed to make the argument. Certainly.
Because they can make the argument, because there's evidence that supports it, I think it's appropriate to give it, so I will remove the highlight there, and that will stay in. I think I will now remove the highlighting from this mortality table because I get it and why it's being used and why it would come in. But I think we're only using one of the mortality tables. Which one is it that you want, the 1949 or the 1958?
Your Honor was correct. Those are old. The 1958 is the one we were, and I haven't even seen looked at the other one, but just wanted to use the most recent one. So
okay, so we are not using the annual mortality table for 1949. We are using, assuming you come up with an admissible version of it, the 1958. Anything you want to get on the record concerning this life expectancy mortality table charge?
No, Your Honor, other than reserving objection until we actually see what's admitted into evidence.
And if what Mr. Ramsey presents is not an adequate and admissible form of the mortality table, this charge is out because there won't be a mortality table for them. They can still think about future pain and suffering. They're just not going to have the mortality table to guide their guesstimate as to how long Mr. Shackleford will live. That's it for me. So, Mr. Ramsey, I turn to you. Anything else in this charge that you think should come out or not in the charge that should be in?
and Your Honor, to be honest, I think this came in this morning, so I had not had a chance to look at it in detail.
It's a fair point.
So just of what we covered, no, I don't have any issue.
Okay, then your project, one of your projects tonight will be to go over this, and we are going to start at 8:45. And I will end my scheduling teleconference as close to 8:45 as I can. Then I'm gonna ask you that same question. Is there anything in here that should come out or something I didn't include, or I didn't include, that should be put in? Okay,
Thank you.
Ms. Peeler, you have faced the same time constraints, and I wasn't trying to rush anyone on this, but you may have already seen some things that give you pause.
Your Honor, we'd like to look at it again tonight, this evening, and discuss with the court tomorrow. One thing I do want to flag for the court's attention is we filed an amended charge this morning with the court on future medical expenses. Basically, I think the jury heard an opening about a potential surgery. I just think given that that surgery evidence has been excluded, there's been a directed verdict on it, there should be a jury charge to instruct the jury that they're not to consider any sort of damages for surgery.
Okay, I don't disagree with you. What will probably happen if you look on the screen now, the Zoom screen, is we'll probably add a sentence where I'm typing a bunch of Fs. It won't be a separate charge, but it will be, because that relates to expenses. And it would be a sentence that addresses your concern that they're not to consider or award any future medical expenses because they would be speculative based on the record. And we'll wordsmith it, because I don't want to be critical of the record that was made, just make it plain to them, because the verdict form I'm thinking of doesn't say break out all your numbers in these different ways. It's we find for the plaintiff damages in the amount of X, and it's got, but here's his percentage liability. So I think we do need to make plain that future medical expenses are off the table. So I would be open to language right there. We'll make it say something different than that. Anything else that you already know we're gonna have to talk about in the morning?
No, I'll take a chance to review it tonight so we can make the objections in the morning.
Okay, great. Then that'll be the plan. Mr. Ramsey, anything else that you wanna get on my radar for tomorrow?
And this may have been one that you skimmed past and I just didn't see it. And this was not one that I thought at the time to ask in a request to charge. If Your Honor remembers at the outset of the case, we said, hey, we're going to dismiss Mr. Morris individually. And I believe there was even a stipulation that, he was working within the course and scope of his employment at the time of all this. Maybe just some blurb about respondeat, maybe not say respondeat superior, but just say, at the time of this accident, just something where the jury can understand why hey, the defendant is Georgia Power. It's for the acts and or omissions of Mr. Morris and how that works. I don't have it wordsmithed perfectly
Well, that's
right
a
now.
fair point, and that crossed my mind when I think it was Mr. Archer who was actually announcing your dismissal, but whoever brought it up, and it turned out not to be presumptuous, it turned out to be accurate. But it crossed my mind, well, I want to avoid a situation where the jury says, well, we find for the defendant because it was Eric Morris who was negligent, not Georgia Power.
Right.
So I'll present some language in the morning.
Okay.
And then we'll see if there's an objection. Conceptually, I'm open to it, so I think it will be a linguistic issue for you as opposed to a concept issue. Just so that jurors don't get stuck on that, because I would answer their question if they were to submit a question during deliberations. Wait a minute, how is Georgia Power liable? And I would need to explain all that. Let's avoid that confusion. Anything else from plaintiff?
No, Your Honor.
All right, Ms. Peeler, anything else?
Nothing else right now.
You'll be handling the direct examination of Mr. Kidd?
Yes.
And while you said it wasn't 15 minutes, you made it sound like it wasn't gonna be all that long. That's helpful to know. It's not a 3-hour presentation.
Correct. I would think maybe 30 minutes, maybe 45, depending on how many questions the jury has to ask.
Sure. Okay, got it. Well, super. Let's make sure he's ready to go by 9. We'll get through the rest of the charge conference. Let's go off the record for a moment. Ms. Fuse, you're with us tomorrow?
Yes,
Are you able to be here by 8:45?
yes.
Excellent. Then let's do that. We'll go back on the record. I think that's it. Anything else before we adjourn today, Mr. Ramsey?
No, Your Honor.
All right, Ms. Peeler?
No, Your Honor.
All right, thank you everyone for your time. I know this was a slightly different window, 1 to 6, but it went well. We got through a bunch. We'll see you all at 8:45.